For tomorrow.
When the action of this one, position of this one.
My lord, the opposition order was passed by the district collector on January 1st, giving 60 days notice. Prior to that, they are making an attempt to take the physical possession matter. Even, but without considering my notice proposal, my lord, because we have, my lord, we have given a proposal to settle the. Pray for tomorrow, my lord. I will.
Maybe.
Tomorrow. My lord. No.
May I be permitted, my lord's lordship? This writ appeal, your lordship had heard on 2 occasions. It was specifically listed, adjourned to yesterday. Yesterday it was mentioned, your lordship, I have filed an interim application. The date has been, as per the judicial order, it is 24th of March. But the short order says 24th of February. Unless this matter was once remanded by the Honorable Apex Court, your lordship will recall. No, your lordship. Time was not fixed, but. No, not coal bearing, your lordship. This termination of the appellant from the year 1990, your lordship will recall. 24th of February, your lordship had specifically adjourned. May it be taken up anytime?
Anytime after 2 weeks.
I don't know, mention matter. This is a pension matter, matter. State preferred an appeal, matter.
You all matter except that one.
My part. My lord, one review, lordship.
Precious for us. Waste of adjournment in office.
The petitioner is a trade union and they are debarred from attending the meeting, and the meeting is scheduled on 1/3/26. Even they are debarred from the safety committee and all. Lordship may hear it tomorrow. 1/3.
Lord, one highly review petition passed by this challenging the order. Lordship, tomorrow, lordship, because of that, this one.
Yes.
Item number 23 on board. My lord, my learned senior is out of town due to personal income. Matter may be taken up some other demand.
Serial number?
23, ma'am.
23 of today's list.
Yes, ma'am.
Nothing. We got to let the request of inform the other side.
Yes, ma'am.
If the other side comes and argues, we'll hear.
Yeah, virtual mode.
Lord, I am appealing for the petitioner. I am for the opposite part number 2, man.
No, we see. Very good. Very good.
Lord, if Lordship considers to adjourn on the next week, if it is possible, Lordship.
Next week, all right, next week.
Obliged, Lordship.
Pardon to mention, lordship.
Oh.
My lord, this matter was heard by the full bench. After the full bench given view, it was remitted to this court. My lord, the tenure of the petitioner is coming to an end. He has been out-seated as Sarpanch from a long since. His tenure is coming to an end. The matter may be heard.
They have it tomorrow.
Obliged.
My lord, item 27.
Can we have it a week after next?
Tomorrow will be.
What's the urgency for the elected man?
His tenure is coming to an end. News is coming the Sarpanch election.
When it is coming to an end? Don't go by paper news. Paper will tell that the heaven is falling down.
The tenure is actually coming to February 2027, my lord.
February 27. Yes.
Pardon, your lordship, can item number 12 be adjourned for a week?
12.
Yes, sir.
Which year matter?
Sir?
26. After 12. 2 weeks. That's the request of?
Yes.
Who?
Sir, I'm appearing for the petitioner, sir.
Petitioner. That's the request of. Yeah.
Thank you.
Pardon, your lordship, item 27.
27.
Yes, my lordship. This matter be taken up 2 weeks later. I'm for the opposite party, man.
For the opposite party.
Yes, your lordship.
Whether you have informed the other side.
No, my lord. I am for the petition, your lordship. In this case, pleading has already been completed, my lord.
He wants 2 weeks.
My lord, 4 persons has been terminated from their service. 4 persons has been terminated from service.
How? When it was?
It was in 2025 itself.
25. Termination was 25.
Yes.
All right, we'll have it after 2 weeks at the request of finally. Yes.
Now, supplemental list for judgment. Item number 1.
Upon a deliberation with my lord, this has been ordered in these circumstances and without disturbing the appointments already made, then such appointees have accrued rights to the post. We are inclined to direct appellants to accommodate the two respondents against existing vacancies in the post of dental surgeon, Junior Odisha Medical Service cadre. Such accommodations shall, however, prospectively. We have differed with the reasoning assigned by the learned single judge.
I agree with my brother. It's a good judgment. Youngsters on service law, they just look in. My brother has taken a lot of pains. Yeah. Personal appearance. Yes. What is personal appearance?
My lords, in fact, there was some delay in filing the charge sheet. So, your lordship, I have given the
Explained why delay happened.
explained,
It was
my
not
lord.
some delay, long delay it was.
Long delay, my lords.
Where properties of others were.
My lords, the present was joined in March, my lords, February 2025. Earlier to that, it was 2 years delay already there. And after his joining, the IO has taken prompt steps and
So how he has done? Ask him to share the diary, the material.
I have given, my lord.
You have given that? Yes. Yes.
E-filed, it has been e-filed. My lord, he has tendered apology for the delay.
Apology.
My lord,
Is sufficient. Anybody was arrested?
my lord, he was granted anticipatory bail.
Anticipatory bail. Matters like this. Only one person.
Another person is paid. Dead, my lord.
He's dead. That's good thing. Yes. Go to our order. Now, are you happy with this? You have done this one.
My lords,
This, because he is saying
he is not to
early.
be, my lords, from the prospect I see it, he is not the one to be blamed. Now, there was a statutory duty which was casted upon the sub-register who had allowed this registration to verify the identity of
Whether sub-registrar is also examined.
My lords, examined.
Examined. Is he set up for trial?
My lords, no, my lords, he is not accused. Actually, he had lost the affair, my lords.
No, he could not lose the affair. But suppose if the thief lodges the FIR, is it ground for leaving him?
My lords, there is a
No, you say that you do not find any prospect in the person who is held to be responsible as an accused here. And you say that, he says that this sub-registrar is also not.
My lords, there is not that.
Who is
one.
that?
But I'll explain.
Both are in hand in glove.
My lords,
That is how all these things are.
my lords.
That is what
Not
my lord is saying.
not the sub-register who has filed.
Yeah.
I'm so sorry.
Says you are not Socrates.
I'm so
You
sorry.
answer within seconds.
I'm so sorry.
Is it not? You are
I'm
a
so
technical
sorry.
person as we are. Process what brother is saying for a moment. Don't be impulsive in the court. Mr. B.R. Naik was the sub-registrar at that time.
Mike.
Have you examined him?
My lords, he was examined. Examined, my lords. IO has examined him.
Why he did not ascertain identity of the executant? The apex court has several high courts have taken the view. Sanjeev Rao on it.
My lords, what
registration.
happens, my lords, they create fake IDs also. Impersonation,
Fake ID is all right,
my lord.
but they come and sit
Because now everything is taken on photos and other things are taken, my lord.
correct, but the executant comes to the sub-registrar's office
My lord.
and sits in front of the webcam. Could he not identify?
He will be identified by a fake ID, Aadhaar card. They are creating that also, my lord.
Then nobody is proper. Do you own a house? You assert whether it is in your name or not. Then
My lord, I had a client staying in the USA.
Same happened. No, in Bangalore it happened. He got arrested, 7 lawyers and 7 other accused persons, 14 persons. After that, it stopped. Yeah. Now, this is because safety to life, security to property are essential for an organic
Now
society.
it has been reduced. Now it has been reduced. Earlier it
What
was.
is the trial stage now? What happened?
Trial has not begun.
Not begun. Why?
Not someone is to be issued from the court. And,
By our order dated 10/2/2026, we had said as an You are a DCP Bhuneshwar?
no, my lord.
Huh?
He is the IIC of that police station.
Police station.
IIC Jatni PS.
With English, elementary knowledge of English. We had said as an this day, the concerned IO, Mr. So and so,
He is not the IO man.
not IO,
Not
we are
IO.
concerned
He is
respect
the
of the
IIC.
police.
IIC of the police station.
IIC means?
Inspector in charge.
The inspector in charge of police station, Mr. Stalin Kumar.
Biswal.
Stalin Kumar Biswal has personally appeared in the matter, assisting the learned DGA, Mr. Begura. First, he has filed an affidavit with a sketchy explanation as to what are filing the charge sheet. What do you call it? A charge sheet?
Charge sheet.
In filing the charge sheet after accomplishing the investigation into the offenses. In what is that number of the case? Case number?
In connection with 273.
Jatni GR case.
Jatni PS.
Jatni PS case number 273
273 of
up to 2023.
2023. First one. Come. Pending on the file of, it's before whom it is pending?
The JMFC. JMFC Jatni.
On the file of learned JMFC Jatni. First one. However, he also tells us that the accused set up for trial has obtained anticipatory bail, and therefore he could not be arrested. He or she? He could not be arrested. He tells us that one Mr. B.R. Nayak, ORS, Sub-Registrar Jatni, who held the office during the relevant period, has also been examined, although he has not been arraigned as accused in the charge sheet. Correct?
No.
He is not made an accused.
No.
First. Investigation, the apex court said in Lalita Kumari versus State of UP, 2014 2SCC 1, belongs to the domain of IO. And therefore, we are not much deliberating on that. First off, suffice it to say that the trial court at the appropriate stage will consider as to whether that person or any other person should be made an accused under section 490, which is that section in CRPC. 319 of erstwhile CRPC, if grounds do exist therefore. First one. Next paragraph. Since matter is serious and has enormous implications to the security of property, which is essential for an organized society, we request the learned magistrate to try and dispose of the subject criminal case.
GR case number. GR case number 534.
The subject GR case
534 of 2023.
534 of 2023 within an outer limit of 6 months. 6 months. Preferably within an outer limit of 6 months. Without being influenced by whatever observation we have herein above made. First one, registry to send a copy of this police, what you call your IIC Jatni shall present this order on the order to the court of learned JMFC. Fourthly, first one, registry shall also send a copy of this order by speed post to the state JMFC. This day itself. Immediately, not this day itself. Let to sign another. Yes. All right.
Personal appearance may be dispensed.
The presence of the police official shall not be, may not be needed in the subsequent proceedings. Yes.
Has this case pending on the question of whether the registration can be set aside or not?
Yes. Say.
My lords, the rule 66 of the registration.
Where the respondent is not here. Who is the opponent?
My lords, Congress Jana is the person who has been arrayed as the opposite party number 2 here, my lords.
Who has been granted the anticipatory bail? No.
Yes.
He has been granted. He is not here.
He is not here.
We direct a police notice to him. Let him come. We want to see his face also.
My lords.
Issue Congress Jena.
My lords.
Opposite respondent number 2, my lord.
Issue police notice to second respondent, Mr. Congress Jena, on urgency basis. Let's serve the notice immediately. Call immediately after such service. On this matter, immediately after such service. Let notice go.
Gratefully, Lord.
Item 2, we can't leave whether you just ascertain whether he has got any other property, etc.
I'll find.
Okay, that may be required for obvious purpose.
Grateful.
Yes.
Item 2.
May I please, Lord?
Yes.
Although I seek some time, Christian,
23, Mr. Padi.
it was not admitted. Yes, Lord, may.
Not admitted.
Not admitted. Lord,
What is the matter? Tell us.
It is against the order of the Central Tribunal Cutter Lordship. Annex annexer 8 is 98 lordship. What happened to lordship? Right credential lordship. The director of printing press.
That is a parity of pay scale.
Yes, yes, yes.
How to decide how
Yes, Lord.
agree?
Here is the case. Because they discussed that paragraph page 100 lordship. Page 100.
Page 100.
Yes, lordship.
What is that you want to say?
I think that
Next range.
in the line was 9th line. Thereafter, by letter of substances office of the postal printing press, Bhubaneswar clarified that since the pay scale of rupees 4,500 to 7,000 has been upgraded to 5,800 repeated to 1 on 2006. And the pay scale granted to ACP from 1 on 2006 bring the same financial upgradation granted under MACP 2. This to be ignored and officials are to get to financial upgradation.
You are classified as master craftsman.
Yes, Lordship.
It was in the year 1992.
92, Lordship.
What is payable to the master craftsman?
Yes, sir, page 66. Page 66, sir.
What is 66?
66.
Page 66.
6, sir.
That is the pay scale.
No, sir, that is the craftsman, when the master craftsman took place, sir.
You became a master craftsman when?
Yes, sir. This is the way back, that is the 1992. This is
1992.
Yes, Lordship. Lordship, kindly say, existing post that is the offset basin line, offset grade 2, and the junior assistant, artist. The scale of pay is revised, that is the classification, master craftsman, all are the master craftsmen.
What is the pay scale admissible to that post, that cadre?
At that one point of time, 1400 to 2300, you know, the pay scale is there, same scale of pay.
Then why tribunal denied that list?
They become that head because of here, Lordship.
You can sit and argue also, no problem. You can sit and argue. That becomes easy for you.
Lordship, page 68.
16.
68, sir.
68.
18 June 2012.
18 June 2012. What is this?
Department post, paragraph 2. Ministry of Finance Department expenditure nearest such and such 28/7/2009.
It requires consideration, Mr. Padi. You accept notice. Issue.
So small technical point is that no such sport is available. He joined as a junior artist.
That post has
But
been.
he has been made the master craftsman.
Yes, yes.
Master craftsman
Master craftsman.
in 1992.
Here is a discrepancy
Yes.
You
there.
can see that. Just examine.
Yes.
Only page 34, you will see that the
Issue emergent notice. Submit the PST Mr. Padi is requested to accept notice for OP 124. Notice to 5 is dispensed. You are not supposed to array the tribunal as a party. His latest judgment, not latest, 3-4 years ago.
Yes, yes.
Of export.
Earlier we have.
Give them copy also.
Yes, sir.
Matter lies in a narrow compass, post in the first week of the page. Yes. Item 3.
Along with me, Mr. Kasumi, has passed on the slip. Item 2, Mr. Kasumi is appearing with me in that.
You are also appearing. Mr. What?
SS Kasumi.
3. He requested to accept notice for. So along with Mr. Padi, along with yeah. Yeah.
My lord, the petitioner is an auction purchaser. He has requested the bank while selling the at the time of auction, as also the issuance of sale certificate. He has stated that the residential house which has auctioned has a connectivity road. But at the time of possession, demarcation was made, and as per the demarcation report, there is no road to the connectivity to the that residential house. So the petitioner made an application for refund of the money. That has been rejected.
It has been rejected.
Madam.
On what grounds?
On the ground that since the term was whereas, my lord, kindly see page 23, my lord, annexure 11.
Auction was eligible.
As for the terms and condition, as is where is and as is what
But
is
you
where
did not,
basis.
you did not pay the money.
Total money has been paid, my lord.
Total money has been paid.
My lord.
You take notice.
Issue emergent notice. That AGA is requested to accept notice for 1, 2, and 3. Emergent notice to 4.
Yes.
1 and 4.
Madam,
J is for one only, my lord.
Only one.
one, huh?
Only one.
Only one.
2, 3, and 4 or no?
Emergent notice to the rest. Yes. Item 4.
Mr. Patjosi, I may place the matter.
We want to place the matter on the.
Yeah.
My lord, here is a case, my lord. To total compliance of your lordship's order,
Yes.
they have approached your lordship. Yesterday,
What's the order?
order was to pay them the compensation, my lord.
Have you paid?
My lord, file is moved, my lord. If they have told me that if 3 weeks time will be sought for, then they will make payment.
We can't.
File has already, my lord, file has already been processed.
Correct.
In time.
But we are only contempt court.
Yes.
If you want extension of the period, you should apply.
My lord,
original court.
I have obliged, my lord. So, my lord, lordship may call this matter 3 weeks after.
Just to
so
record
that-
it after 3 weeks.
3 weeks.
Okay.
So
In
that-
the meanwhile, if they do not do,
Then
Then-
the lordship may.
Date may change. Date may be question.
call this matter on 3 weeks will be when? We'll call it on 25/3.
My lord, yes.
25/3 at the request of. No, 23/3 at the request of learned AGA, who assures that something is being done in the matter. First,
Yes.
something positive is being done in the matter. Yes. Item 5.
Item 5, Lordship. I pray for an adjournment for some issues, Lordship. Can it be on 9th of March, Lordship? We commence in 9th of March. Can it be?
Wait, what's the urgency?
Urgency is there because Union of India, the Department AMC is before you, Lordship, as a petitioner. But in my file, I found some.
10th we will have 10.
Thank you, Lordship. Grateful.
10th at the request of. Item 6. Yes, sir.
Now, I'm appearing for the opposite party. Please, I think
That we have not yet issued notice at all. No, not take it. No, don't take it. We have not issued notice as yet. Yes. Item 6. Yes.
Petitioner files this writ application challenging the illegal action of the IFCO authority, thereby transferring the land without following their own circular as well as the order of this honorable court. Earlier, the bank filed a writ application. I have quoted that order in my
Who are you?
application. The bank has filed the writ application.
Who are you?
I am the defaulter loaning. Yes. Borrower.
What is
So,
your grievance before?
My grievance is that their circular says that vacant land cannot be transferred at any circumstances and prior approval is required.
Prior approval of whom?
IFCO authority. Before auctioning the property, prior approval of the IFCO authority is required by law.
But you had given that property as security.
Yes, security that has been during pendency of the essay before the DRT, that has been auctioned. Bank made that auction mile. My contention before your lordship is that since this is vacant land, their own circular says that it cannot be transferred and it's about admittedly no prior approval has been taken.
No, that is approval.
Apart from that, this honorable court directed earlier the bank approached this honorable court, and this honorable court directed you approach the DRT since DRT says pending mail. No application has been filed, nor a higher forum have been approached. In these circumstances, they issued a letter that you will consider their transfer application. This is
You-
my sum and substance of my grievance.
Understood. But you had furnished that property
Yes,
by way of security for the repayment of loan.
yes.
Did you tell them that I am furnishing this property, but this property cannot be auctioned or sold
Yes,
without leave of
the bank knows, my lord.
what where is that?
This is a Witco property, my lord.
Let ITCO be concerned about that. That is not
Yes.
for your benefit. The condition,
No,
the property, kindly listen to us. Kindly listen to us. We have heard you now.
Yes,
See, when the property was furnished for repayment of the loan,
yes, ma'am.
the condition is, according to you, even agreeing with that, it cannot be sold without prior permission of the ITCO.
Witco.
It is for the ITCO to take action. Who are you?
My contention is before your lordship.
You have said that now.
They have violated their own circular. Their own circular violated.
Why you make them aware? Who is in peril? It is ITCO or the borrower? Who is in
ITCO.
peril? Who is to take up the
Who
matter?
has to take up the matter? It is for the
ITCO
benefit of the
property,
ITCO.
admittedly ITCO property.
Therefore, ITCO will let you file a representation to the ITCO saying that they have done like this.
I made a reference on my. I have made a reference on.
Therefore, they are not bothered about it.
Yes,
You also don't bother.
because my essay is pending before this before the Hon'Ble DRT.
We'll direct the essay to be decided at the earliest, or we'll dismiss the petition. Which option you want? We do not agree. Law cannot be used as an instrument of fraud by the borrower. Borrower should take.
No, I am not playing any fraud, my lord.
No,
This is
we are
the
telling you.
ITCO property. Admittedly, everybody knows.
Where everybody knows and the ITCO also knows. If it wants to take action, it will take. Why do you worry?
Because my property is to be transferred, my lord.
Yes, it is
During
not.
pendency of the essay, my lord.
Correct. Therefore,
If essay I will win,
no. If you win,
then
everything
how
will
can
be
I get
success.
that property, my lord?
Because you have won the property, the litigation. In the event you win in the
Yes.
essay,
Yes.
all that will be subject to outcome of the essay. This pendants of life.
This observation will help.
Uh, the petitioner borrower is knocking at the doors of this court. Seeking quashment of the letter dated 19/1/2026, a copy whereof awaits at Annexure 5, and the same reads as under. Next paragraph. Learned counsel for the petitioner vehemently argues, kindly be seated. Vehemently argues that the subject security property cannot be alienated without prior permission of the ITCO, and any decision of the bank to the contrary is liable to be set at naught. First one. He also tells us that his essay number
136, my lord.
136 of 20.
23.
23 is pending on the file of DRT Cuttack. First stop. Next paragraph. Having heard learned counsel for
That
the
is, my lord, I am sorry, 134.
134 of
2023.
2023.
Para 8 is there.
Para?
Para 8 with
Okay. 134 of 2023 is pending. Consideration on the file of DRT Cuttack. First stop. Next paragraph. Having heard learned counsel for the petitioner, having perused the petition papers, we do not propose to entertain the plea of the petitioner in as much as his essay number 134 of 2023 is pending consideration before the DRT, jurisdictional DRT, wherein the relief which he has claimed here can be subject matter of adjudication as well, by virtue of the doctrine like list pendants enacted in section 52 of Transfer of Property Act 1882. First one. Next one. In the above circumstances, and with the above observations, petition is disposed of. Okay. Then you need to send a copy of this order to the OP bank. OP's by speed post. Okay.
Item 7.
Item 7, the petitioner challenging the order of the Land Central Tribunal. The annexure 8 of the writ petition. The crux issue of this case is that the petitioner was working as a Gramin Dak Sevak, and he's committed fraud of near about 60 lakhs, 56 lakhs, 97,319.66 paisa.
What he did?
He has taken money, misappropriated and taken money, and again he transported his own account and committed fraud. But this, even though he is coming under the category GDS, this observation of the Land Central Tribunal is that particular line I am reading, the paragraph, page 143, paragraph 12, Lordship. In the instant case, the applicant was placed under the portion of duty on 29/9/2022. The charge sheet was issued to him on 6/4/2023, and no order for extension of the suspension period or report of the review committee has been passed. Therefore, in the circumstances of the case,
the suspension is set aside. Yes. They are not quashed the proceedings.
No, but here is the case. What I am going to crystallize before my lord. He is not a civil servant. The GDS of the postal department knows that they are coming in a special control. That's why GDS rules has come into force by the government.
Not a civil servant.
He is not a civil servant.
Therefore,
so
no
CCL rules is not applicable to him. The CCS rules, I got a copy of this GDS rule.
Yes, Lord.
Karnataka High Court has held that way.
Yes, Lord. Put of duty is equal to that is the suspension.
No, that apart, a person who is facing the charge for maybe temporary misappropriation.
It is not misappropriation.
No, that we have to establish in the inquiry. How can
yes, statute has been issued
issue emergent notice. First off, learned PhD points out the application in IA number
1557 of 2026.
Supported by an affidavit seeking stay of the improved order of the CAT. First off, he tells us that the respondent, the OP, is not a civil servant, and therefore not entitled to invoke the provisions of which rules. Write down and give.
That is called Department of Use Time and Tax Group. We have passed up the copy of the record.
One sentence. Similar order has been passed and implemented by the department.
That's all. All cheats and frauds cannot handle the money of the department.
And that is the verb.
But court's reference has given the GDS also.
First, at the first blush, the argument appears to be true and matter requires deeper consideration. First, in view of the above, application having been favored, impugned the order of the CAT is stayed until further orders. And as a consequence, the suspension of the OP would continue. Next,
this last week of March.
Calling the
Because it is
first week of second week of after reopening of the court, call on the reopening of the court post summer vacation. Yes. No, but see, lax together he is charged with that. There is nothing liquidation. We do not know all that. Even CAT did not crash.
Simply said that they have the documents.
No.
The documents they have.
Let's see some other good case for you. Yes.
Item 8.
Lordship, this was an auction matter, Lordship.
Remember,
my Lordship. The auction has been held on 9th of this month, Lordships.
9th of February.
Yes, ma'am.
When did you borrow?
I was the defaulter, my lords, had come before.
No, we're asking a question to you. We have answered that question. When did you borrow?
13 lords.
2000. How much you borrowed?
My lords, it was 20.8 crores, my lords.
20.808. What is the rate of interest?
12%.
Commercial loan appears to be. How much you have paid back?
Plus, I have paid around 30.
30 lakh, 30 crore you have paid. Is it due? Has he repaid 30 crore?
Aggregate date.
Aggregate.
Let's say the company is under insolvency now. Company is under insolvency, then it has now gone into liquidation, the company.
Whether a liquidator is OL is made a party.
Yes, I am appearing for the.
You are for the OL.
Liquidator. The matter is pending for the NCLT, and NCLT has already directed liquidation order, and pursuant to that, auction sale has been carried out. The reserve price was 20 crores. The successful bidder has placed a bid for 32 crores, which is a 60% more than the reserve price.
Yes.
And LOI also, Millets, has been issued in favor of the successful bidder. LOI also has been issued. This is the copy of the LOI, Millets, which has been issued. So, Millets, this auction that is under challenge in this, that has fructified in a very successful outcome, Millets. 32 when a reserve price was of 20.
When it happened?
That's on 9th of February, the auction got completed.
What is the market value of the property?
Market value would be much more, lordships.
How much?
But I would have to take
here. What happens under liquidation, Millets? When a property is put for liquidation, before that, under the IBC, Millets, there has to be a valuation exercise that has to be carried out. Valuation exercise is carried out. It was arrived at 20.91 crores.
No appeal on this to the national.
It is there. In fact, my lords, on the previous occasion, there was an earlier writ filed before this court again for the same relief that my OTS may be considered. There, your lordships have held that the NCLT is in session of the matter. It can be dealt with by the NCLT if at all any grievance is there.
That is even against this grievance.
Yes, Millets. Here, Millets, this is any decision of the liquidator, Millets, can always be challenged before the NCLT. Day in and day out, Millets, these are happening before the NCLT.
Millets, I'll take lordships to page 149. The order of the liquidator.
149.
Page 149. Para 4. This is the order of the NCLT, my lords. This is liquidation order. May I read, lordships?
Yes.
In furtherance of the recommendation of the COC at its 35th meeting, the liquidator so appointed shall explore the possibility of selling the corporate data as a going concern under Regulation 32E of selling the business of the corporate data as a going concern under Regulation 32A. My lords, I being the promoter, man, I had put in an offer of 22 crores as OTS costs. They did not accept it. I also came forward with a 5 crore demand draft. At that point of time, it was subsequent to this order that they were selling it at a slump sale manner, not as a going concern. So as because I have the required papers from the government to operate, if I get it back, otherwise in a slump sale, they will have to wait for 3 years moratorium period for restarting the unit, or they may sell it in piecemeal manner. Presently, my suggestion, lordships, before your lordship, is that I have placed an additional affidavit, wherein I say that I am prepared to match that 32 point whatever amount they have got in the auction, because the sales certificate has not been issued. And I am the promoter. It's a going concern. I can operate it because I have got also investors who are agreeable to it. And I am also taking instructions from the promoter here, mayors, that they are going to come up with the amount within 7 days if lordships permit us. If we are able to retain it, otherwise, my lords, they may proceed with the auction.
Whether the auction buyer is also party.
No, we do not know, my lords.
You reveal who is the auction buyer.
Yes, because they know. They have annexed the additional.
Let's have the ACC meeting on.
Yes.
We do not know the identity of the auction.
Very well.
You give now you call your client and I'll give him.
Yes. Right now. I'll right now give it.
Suppose if 32 crore comes to you,
Balance.
You cannot have any grievance at all. At the most, buyer may have, auction buyer may
Only
have
thing,
grievance.
Millards.
For him, we will give the solatium under Order 21, Rule 89, 1991.
Only thing, Millards, may I just indicate, this is governed by the liquidation regulations.
That's all.
Under liquidation regulations, Regulation 33 says the liquidator can sell by way of the manner prescribed in the Schedule 1 of the liquidation.
Correct. Now it is sold and we have understood all that. Your interest cannot be more than the money which you are getting from the auction buyer.
Yes.
Suppose if he is ready to pay that money to you and he wants to give solatium to the buyer also.
May I just,
how you will be agreed?
may I then submit one thing, Millards? Millards will kindly call this matter on Monday. I'll take instructions in the meanwhile.
But in the meanwhile, you implead a petitioner.
Let them inform us who is
I will. After the court, Millards, I'll inform Mr. Sanant.
Not after the court. Right now you have to tell so that you have to make the order.
Yes, your lordships will see that LOI that I've
You
given.
will not see all that. You give that.
Millards, I'm handing over the LOI where the name of that
Have you
particular
issued the LOI already?
Yes.
When it was issued?
Issued on 10th of February.
But till next date, you don't precipitate the matter.
Millards,
Otherwise,
it is governed by liquidation regulations, Millards,
Correct.
which says
No.
that the amount, may I show the liquidation regulations? It says, I'll tell your lordship how. The liquidation regulation Schedule 1 says mode of sale.
auction.
There is a mode of sale that is prescribed.
Correct.
It says, on the close of the auction, the highest bidder shall be invited to provide balance sale consideration within 90 days of the date of such demand,
Within 90 days.
provided that payments made after 30 days shall attract at interest at the rate of 12%. So
Correct. Now he has already made the payment.
he has not made the payment. He has in the
We wanted this statement from you.
Millards.
Now, he has got how many days time?
At least
90 days.
90 days time.
90 days.
Therefore, don't precipitate the matter. We will implead him. After all, you want money. He is ready and willing to organize that money from outside, whichever way, except that he will not counterfeit them.
Millards.
Your interest will be served.
That's only.
That's all.
Very good.
That's all.
Here, I just wanted to last submission.
To show bona fide.
Last
Where
submission.
is the money now? What money you have?
Millards may give me
You put when you put
well, by Friday, when I am instructed by Friday, we'll deposit 50% of it in the registry law.
Millards, I'm just showing Millards this. Millards, what exactly same relief was claimed?
And after all, what you want is money, and he is paying that.
And this writ
Therefore,
petition.
grievance can be only of the auction buyer. Suppose if they can sit and negotiate a deal with an auction buyer, that such decisions are there by Justice Rajamanna of Madras High Court under Order 21, Rule 89, 1991 of CPC, where the judgment debtor who loses the property because of auctioning, he can seek payment of solatium to the auction buyer and retain the property. That's the judgment.
Yesterday, your lordship,
Well, let me
deliberating
just
another
seven-
matter.
In fact, we deliberated on that.
Yes.
Millards on reopening on 5th lordships by 50% I'll deposit lordships.
Let's, may
No,
I?
you said before Friday.
Friday I have a 5 crore check demand draft lordship which can be deposited to 1 day time because physically I'll deposit in the registry.
May I indicate
But
what
another
happened?
3-4 days Millards are required
This
for
5
making
crores is
50%.
given by an entity called Valve Tech. This very Valve Tech, after your lordships refused to interfere on the first date, this very Valve Tech filed an IA before the NCLT. NCLT saying that we want to participate, and at a belated stage when everything was over, at that stage,
They
on
are
the-
concerned of the money
and
Millards.
they themselves, Millards, filed that IA, and subsequently they have withdrawn that IA, saying that it is infraction. It's this very, I just
We understand content also. Anyway, now immediately they will pay
by Friday,
5 crore day
By
after
Friday.
tomorrow,
My Friday.
and 10 crore
By 5th lordship.
5th of March. You deposit in the registry.
Please, Lords.
may I, Millards, suggest, subject to my lord's consideration, would your lordships call this on Monday, Millards?
This Monday.
Yes, please.
I'm sorry. Monday is on.
I'm sorry. Fifth.
We'll come to
Fifth.
9th of
5th minutes.
all right.
Because I'll tell you lordship the difficulty on my part.
Maybe.
We are
reasonable.
But the only thing is that these proceedings, there is a prior order also where your lordships refuse to interfere. I may be misunderstood.
No,
that's
What is the question?
No,
Assembly.
no,
You are passing order on that.
yes.
Heard learned counsel appearing for the petitioner and learned panel counsel appearing for a bank.
And for the liquidator.
Appearing for the liquidator. Since company is in liquidation, petitioner.
Yes, company is under liquidation.
Since petitioner, you are on behalf of the company now.
Yes, ma'am.
Cannot represent
But how
the
can you
company.
represent the company?
Ex-directors, man.
Huh?
Ex-directors.
Exactly.
Who represents the ex-director, who happened to be the ex-director of company, now with liquidation. First one. Learned counsel for the petitioner submits that the subject security property has been auctioned for a sum of rupees 32 crore on 9/2/2026.
32.61 crores.
32.61 crore on 9/2/2026. And that the clients are ready and willing to retain the property after making the said payment. First off, he also expresses willingness to pay the solatium to the auction buyer if there is such an arrangement. First off. However, this plea can be considered only if the auction buyer is also arrayed as a party to the proceeding. First one. Next paragraph. Learned senior panel counsel appearing for the liquidator.
There's no panel. There's no panel.
Advocate appearing for
Advocate for
the liquidator submits that after having already been accomplished and the auction proceeds being more than 60% of the minimum price notified, already
LOI, letter of intent
letters has been issued to the auction buyer on
10th February
2026. Samitula, has he made the payment now?
No, the payment will come. There is a statutory
schedule is there. He may make the payment within the specified period under the schedule.
As per liquidation regulations 2016.
As per the liquidation regulations
2016.
First one. Therefore, first one. He also tells us about the dismissal of WPC number 21605 of 2024. Disposal of 2024 by a coordinate bench wide order dated 5/9/2024. First one, he opposes granting any interim relief in the fitness of things. First one. Next one. Having heard learned counsel appearing for the parties and having turned the pages of paper book, we are inclined to grant some reprieve to the petitioner in as much as he has agreed with the proposal of this court to show his bona fide by depositing a sum of rupees 5 crore on or before 27 to 2026, and another sum of rupees 15
Make
crore.
it 10 crores. Make it
12 crore. No, it should be 13, another sum of 13 crores. That will be 18 crores. That's all right. 12 crore. Another sum of 12 crore on or before on or before 7th of February. 7th
March.
February. March. You are right. 7th of March. In the registry of this court. First, as already mentioned above, he is ready and willing to give solution to the auction buyer. First, next, in the above circumstances, the petitioners are directed to array the auction buyer as a OP number. OP number 3 right now, whose particulars have been furnished graciously by from the bank side, liquidator side, from the liquidator side. First one, the petitioner has to make a deposit of the agreed sums of money in the registry as undertaken. First one,
just one thing. Insofar as precipitation is concerned, because there cannot be any precipitation.
No, if you say that, we will record it.
Because I'll tell you, Lordship, why. Because any which way he has 90 days to make the
But
payment.
he may come tomorrow.
He is anyway a party. Before
Let us. The further steps pursuant to auction dated 9/2/2026 shall not be precipitated till next date of hearing. First, issue notice to newly added OP number 3 by way of issue emergent notice to newly added OP number 3. First, it is open to the petitioner to take a hand summons to the said OP as well, in addition to taking usual steps. First, call this matter on 10/2. 10/3. 11/3.
11.
All right. 11/3 will have.
11th.
Subject to work in another date.
11th. That's your Lordship may failure to comply with your Lordship will entail vacation of your interim order.
Not interim order. Dismissal of the petition. Failure to comply with the undertaking would entail dismissal of the writ petition. Not interim order. The whole writ petition should go. We are only very we are with constraint because we have to do justice also. Only for the yes.
Obliged.
Yes, next.
Item.
Yeah.
And I am for the petitioner. Pray for an adjournment. I pray for an adjournment.
Request for adjournment. All right, after 2 weeks, that's a request one. Published. Item 10.
My lord. This case, my lord. Notice under challenging the notice 10 glance annexed to 1 minor. Less 10 minor. Here, my lord.
One.
My lord.
Demand notice.
Demand notice, my lord. Under section 32 minor. Under section 32 minor. In outstanding dues, my lord, interest overdues, my lord. Middle portion, my lord. 1,70,000 in say housing loan and another is 75,120 my lord. This is the overdue my lord. I have obtained the loan my lord. I regularly pay the installment my lord. Never defaulted. Never declare my account is NPA my lord. And next 3 series my lord, I have already last 3 months I have deposited the money slip and after year my lord. Here my lord. And they demanded the interest my lord.
What is my lord?
Yesterday my
I have taken instruction. Was posted yesterday. And here my lord 64 lakhs. The due. 64 lakhs. 14,000. What are the installments due? Tell me.
No my lord.
He has taken. We are asking him. You may say no always.
Sorry my
lord. Loan taken. Loan taken is how much? My lord, initially 30 lakhs. 13,823 is the taken over loan from ICICI Bank. 30 lakh 900. 30 lakh. 13. 13 lakh 14,000. Yes. Thereafter, another loan taken of rupees 25 lakhs for renovation of the duplex. Housing loan it is. Housing loan. So 25 plus 13 is equal to, it will be 38. Yes, Lord. In that, in respect of the first housing loan, that take of loan, that installment was 28,277. And second loan, 33,360. 28 plus 33. 20, 30, 50, 61 lakh, 61,000 about. Said that the husband has taken a credit card loan, wherein the due is indicating as on today 11,65,224. This property is by wife or husband? The property belongs to husband. So my respectable submission before the Lordship, classification of the NPA is always a borrower wise, not account wise. The reason being that credit card loan is indicating 11,65,224. If that amount to be paid along with the overdue amount with regard to the housing loans, only 2 lakhs. That means 13,65,224 will be paid. His account will be upgraded. Very well. He will make that payment.
No, may Lord. I clarify my. So far is my housing loan is concerned, my lord.
You go before the DRT.
Please appreciate my lord.
Why appreciating? You have a forum. Why we should not take all that? What for?
Here, my lord. I agree. My Lord brother has agreed to accept my over interest 2 lakhs of housing loan, my lord. So far is concerned another sub item at 2, my lord. That I am challenging the credit card. I have obtained the 80,000 rupees 2016, my lord. 2016 my lord, now the 2025 my lord. The bank has not initiated any proceeding against me. All of a sudden my lord, 8 lakhs my lord, now the 11 lakh demanding the 11 lakh.
So what to do?
Before Lordship I praying.
What is used by you or by somebody?
As per the guideline, RBI guideline, they cannot tag with me the asset property my lord. Here my lord,
you go before the DRT. We are not interfering.
Why I am saying my brother has
we are saying is DRT is established.
I'm just showing just showing my brother has arguing this matter and saying that I just your lordship only
to see brother we are not super only we are central. You don't want
time and glass only.
You don't want to listen to us. It is 64 lakhs. You made up your mind like
my lord. Only your lordship. I am not. You came before your lordship. Only the great hope, my lord. Your lordship. Kindly visualize the DRT observation, my lord. They cannot tag with the another. Even suppose, my lord, I have not a housing loan, my lord. I have obtained a credit card loan in 50,000 something. How they recover my amount, my lord?
Because this is a writ court. Writ court can say to show your bona fide, do this. We are not bound by other constraints.
That's why I am paying your lordship. I am agreed to pay the interest, my lord.
No,
The lordship direct to some interest may be imposed. Some 2016, I am ready to pay that amount, my lord.
You are ready to pay.
My lord.
How much money you are paying?
Your lordship fix the amount, my
No,
lord.
we are not signatories to your loan agreement.
Kindly glance Annex 3, my lord. They have not indicated rate of interest, my lord. Not mentioned the rate of interest, my lord.
You want to argue like this or you want relief at our hands?
No, I am not arguing, my lord. Before I am appreciating, my lord. What is my difficulty, my lord? I have obtained the loan, my lord. Only credit card 80,000, my lord. Now they have initiating. But now all of a sudden, my lord, they are starting
Any amount that will right now fix, will you pay?
Your lordship, I have agreed to even in my 80,000 the principal.
Yes, second argument.
No, man.
If you say yes,
your lordship fix the interest, I have pay that amount.
You can't fix that way. How can we fix the interest?
We are not the bank.
I have asked for the 12% interest, my lord. 6% is normal interest, 6%, my lord.
He will not allow you to argue.
I am agreed to
only.
I am agreed
allow you.
No, man. I am agreed to pay
No.
only 12% interest. Why should I pay before a lordship?
Why can't you improve your advocacy skill? Going to some school.
That's why, my lord, they have not initiated any proceeding.
You ask him what is his.
This is the monetary claim, my lord.
Sit down.
With regard to the credit, he will pay the 11,65,224 and 2 lakhs. No, he will give up the property value is 90 lakhs. That is the.
No, that you want to eat away the property.
No.
Some cases we have observed where banks, officials of the banks are handing blow with the intending payers.
How the money will come?
We understand. Therefore, he is ready to argue than giving money.
I am not arguing.
Please sit down. Sit down. You do not. You have to learn advocacy skill. You are vocal. That's useless to you. You are not in a position to take the court along with you.
13,65,000. In which manner he will pay that?
14 lakh.
13,65,000.
If you ask him to pay immediately, he will jump from the first floor of the court. You will have to give some reasonable timeline, na?
Your worship kindly.
Anyway, even if you give time, that also carries interest. And you have nothing to lose.
Then depends on the interest.
All right. Now, how much? 13.65 has to give?
Milord, because the total due is 64 lakhs. If you will pay the 13,65,000 matter.
On what basis you have calculated this?
Milord, so far the credit card is concerned, like the 11,65,000 is 12%.
But he is saying you can't tag that loan to this loan.
My lord, they have filed the 2 rates, and accordingly we have also not added that the dues with regard to the housing loan is 1, and with regard to the credit card is 1. But the classification of the NPA is always borrowerage. If he will not pay that the outstanding of the credit card, say NPA must be indicated in the system.
By protocol, it happens.
Yes. That is circular of the Reserve Bank of India. That is the crux of the issue.
Anyway, he is expressing some difficulty. You pay 13.65 within the 4 installments.
Oh my, yes, I am not.
You not pay.
I'm not able to pay my 13 lakhs.
Why? But otherwise, it's a bank money.
Bank money, my lord. But only 80,000 rupees.
We don't calculate all that. Your card, who used it, we do not know. You might not have.
I pay a lot. Within 12% interest, 2017, my lord, when I'm obtaining the credit card loan. Till today, I have agreed to, as per the bank rules, my lord, 12% interest I have given. Whatever amount will be taken, I will pay 7 days, my lord.
No, we are not saying this money you have to pay to the bank to obtain a relief at our hand.
My lord.
Then bank will calculate. You can sit with the bank and work out your calculations. We will not do this. We will say you will pay around 13 lakh within the 4 installments. Then you go, if you make that payment, we will say you don't take any action.
I pay first installment, your lordship direct bank to consider my grievance, the interest calculated the 12%, whatever amount will be
You go and sit with the bank manager. Your client should go and sit with the bank manager across the table, and he should work out all this. Red court will not do all that. We are not signatories. Both myself and my brother are not signatories to your loan documents. Therefore, we have limited role. In these two petitions, the grievance of the borrower is against the coercive action of recovery instituted under the provisions of Surface Act 2002. First one. Next one. Learned counsel for the petitioner vehemently argues that the housing loan is only 38 lakh, that is 13.14 plus 25. The other loan which bank is claiming to be how much?
11,65,224.
11,65,225. Even if it is true, cannot be tagged to the housing loan. First one. Learned panel counsel appearing for the bank repels this contention, saying that under the extant RBI guidelines, the NPA certification happens by a protocol, and therefore the coercive notice under 13.4 cannot be faltered. First off, he also tells us that the petitioner has got an alternative remedy which he can explore before the jurisdictional DRT or such other authority. First off, so contending, he seeks dismissal of the petition. Next one. Having heard the net counsel for the parties and having perused the petition paper, we are inclined to grant a marginal interference in the matter, mainly because of the financial difficulty vociferously pleaded before us by the petitioner. First of all, we also agree with the proposal of learned counsel for the panel counsel that if the petitioner pays rupees 13.65 within reasonable installments, the bank would not take coercive steps for recovering the loan, provided that other installments are also duly maintained. First, a writ court cannot conduct itself as the sitting in the armchair of the banking businessman. First one. Next one. In the above circumstances, these petitions are disposed of, restraining the bank from taking up precipitatory measures in terms of the impugn notice dated
17 to 34 miler. 13.4 miler. 70 to 26 man.
17 to 26.
17 to 26.
Issued under section 13.4 of the Act. If petitioner pays 13.65 lakh in 4 equalized weekly installments, fortnightly installments.
Six installment, my lord.
If in 2 weeks you pay 13, even if it is 14, that will be divided by 4. All right, that will be around how much it will be? About 3 lakhs. Around 3 lakhs it will be, less than 3 lakhs. Fortnightly installment. First one. He has to maintain other installments as being due as well. First one. In that connection, we can sit across the table with the banking officials and work out the remedy in accordance with law. First one. No cost. All right.
My lord. Then they have not considered my credit card amount or etc. They already
No. Yes, they're coming back within the
they talk with the contact with the petitioner, my lord. Contact the petitioner, my lord. He wants to withdraw and go to appropriate
Which matters?
item 10, my lord.
10.
Where
You want to withdraw the petition?
My lord. And approach the appropriate forum. But we are not able to pay 13 lakhs.
Should have said after giving the order, we don't permit like that actually.
Sorry, my lord.
Having elaborately argued the matter at length. Come on. Learned counsel for the petitioner seeks leave to withdraw the petition with liberty to approach
Appropriate
the alternate remedy. Avail the alternate remedy in accordance with law. First law. In the above circumstances, petitions are disposed of as having been withdrawn with liberty as sought for. First of all contentions are kept open. You have wasted lot of time. Yes.
Item 11.
May I please you?
To recall the order. Yes, inform your friend also. Yes.
May I please you?
Yes.
The petitioner is a hotel, your lordship.
Hotelier.
Hotel.
Hotel.
The hotel is approaching before your lordships. In 1981, a term loan was.
Hotel means it's a company.
It's a company. It's a company. If your lordship sees at page 18, if your lordship sees. That's on. Annexure 1. If your lordship sees.
OSFC matter.
Yes. So no.
Loan is how much?
Loan is around 30 lakhs. Disbursed around 25 point odd. This is that an additional of 24.4 was the initial loan and 5.6 was an additional term. 30 lakhs is the total liability.
Yeah.
If your lordships comes to the last payment made by the petitioner on 21/2/2004, your lordship, at page 33, if your lordship sees.
21?
21th of February 2004. 2004, yes. Page 33, if your lordship sees. Amount of rupees 70,000 was paid.
1770.
Yes. Last payment made.
Loan was taken when?
81.
1981.
1980. Page 34, if your lordship sees. Annex 3. That is the OSFC has written a letter to the Deputy General Manager documentation. Annex 3, page 34, if your lordship sees.
It is 2005. What is the latest position in the law?
That is important, your lordship. Why it is important? I'll say the second paragraph, your lordship, the company has cleared our dues and the issue of NDC is under process. So by NDC, no due certificate.
No due certificate.
Yes. So in 2025, yes, there the Deputy General Manager writes you to the.
Understood. Next, go to next point.
Yes. So then I requested to issue NDC in 2005, 6, 7, 8, 9, 10, 11, straight to 2022. They have not responded to any of my letters. In 2022, if your lordship sees, at page 49, if your lordship sees. OSFC writes, while going through your loan account, it has revealed that the loan account is not cleared and hence no due certificate has not been issued by Berhampur branch. The reconciliation of your loan account is under process and within a short period, exact amount has to be announced.
When did they say the exact amount?
They have not said that. In 2022. Then I write and I make a representation. You kindly give me all the statements. They have not supplied, your lordship. In 2000.
See?
Yes.
30 lakh you had taken in 1981.
It was not this.
We have not yet spoken complete.
I am sorry. I'm sorry.
1981, 30 lakh loan was sanctioned.
Sanctioned, but not given altogether. That is what I was.
How much was?
25 point odd. It is there later. I am coming to that, your lordship.
1 second. I want to assert. 25. How you have paid, repaid this 25? Where is the bank statement?
I'm coming there. If your lordship sees the page 71, if your lordship sees, that is the last letter issued by them.
No, let us get
No, that is
because
their
there is a reason for this.
Yes.
OSFC officials, some of the officials, the Supreme Court said, have committed fraud. This is what the apex court said in few matters. Therefore, what they say is irrelevant. Now you are claiming that you have repaid the entire money.
Yes.
Evidence Act says one who asserts the fact should prove it. Now here in the light of that, we are asking you,
Yes.
where is your statement of account, bank account?
Yes, your lordship. I have, bank account is not there, your lordship. Schedule I have provided.
No, bank, how you have paid? How you have paid? You have paid by bank only.
Since 1981, it's I have had.
All bank, but
As of now, I don't have their letter, the recall of loan
We
letter.
will not go
No,
back to
what I'm trying to impress upon your lordship is that their own loan account says that they have recalled the last letter that they had issued. They said out of 30 lakhs, we have made payment of around 25 lakhs 48,880.
Where is that?
That is at page 72, your lordship. The letter which I challenge, your lordship. If your lordship sees the schedule at the end of the page, your lordship. Yes, your lordship. Total amount paid is 25 lakhs 48,880. If your lordship sees, term loan is of
that is principal.
Yes, your lordship.
Interest.
Principal, total we have received.
24, 44, 59.
Yes, your lordship. Total amount we have paid, if your lordship sees, 86 we have total received is around
8,60,785, not
Yes, sir.
86.
No, your lordship. 86 we have paid. 86 we have paid.
86 lakh.
Yes, you have. We have paid 86 lakh.
Where is that?
This figure is not 86 lakh, that is 8 lakh.
8 lakhs.
This is 8 lakhs, your lordship. The right hand side total, if your lordship sees, that is 8 lakhs.
We have also studied arithmetics in this school.
I'm sorry, your lordship. I'm sorry, your lordship.
We are not Shakuntala Devi.
I'm sorry, your lordship. The repayment schedule that I produce, your lordship, which is at page, the last annexure, your lordship, which is at page 74, your lordship, the dates since 1981 and the amount paid. Though it is not a bank statement, your lordship, it is the schedule prepared by me, your lordship.
It is your preparation.
Yes.
Give the bank details. It must be by bank only, but even going by your schedule.
Yes, sir. I'll try to get that.
You get that and come back. Then we'll
I'll get that because
we'll
if
ask
in
them what they will say.
In that schedule, your lordship, I have paid around 80 for, if your lordship sees the last page of that schedule.
You have paid 83 lakh 51.
Yes, your lordship.
According to your figure.
Yes.
83 lakh.
83 lakh 51,000 I paid.
You give that your bank statement.
And I'll
go with them.
You are
saying
he's
you have received that money by bank transaction.
My lord, I have to take instruction. My lord, only I have instruction to appear. I'll take copy of them. And last time I call it next week. I'll satisfy and I'll bring the statement of account if possible from the 81. All this.
Issue emergent notice, but that panel council volunteers to appear for OPs.
OSMs.
That is all OPs.
Yes.
All OPs. 3 OPs.
First off, both the sides are directly to bring their statement of account from the statement of account. Duly authenticated. First off, come, failing which adverse inference may be drawn. Call on 11-3.
I have made an IA,
What for?
No coercive action, because
Yes,
it's
then you don't take course action because they already paid 80 lakhs and other things. The learned counsel will do that. Learned counsel for the petitioner submit that the client has already repaid totally a sum of rupees 80 lakh.
83 lakhs 51,630.
83 lakh plus all these year And therefore, he being a bona fide customer, borrower, his interest needs to be protected from the precipitation of coercive recovery. First, there is little evidence in support of that, as is reflected in the record. First, next point. In the above circumstances, application in IN number so and so supported by an affidavit being supported by affidavit being favored, the OPs are directed not to precipitate recovery proceedings till the next date of it. Yes.
Copy of the
Item 13.
Yeah. Item 12,
Yeah.
13, your lordship, it's covered by a lordship's order.
You served a copy with your friend.
Listen, sir.
Served on him, so that he should look into it.
Yes, yes, sir. I've also made necessary corrections, Lord.
You have made the correction?
Yes, 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 Lord.
You see the recent development, the Hon'Ble Apex Court.
Yes, yes, yes.
Yes, this court. See, in the just little whatever little change, we can look into that. Yes.
Good.
Item 14.
I will remove the defects next within a week. The regularization of services that has been. Claim of the petitioners for the appellants before your lordship. Regularization of services. They were what?
If it's to be removed within an outer limit of 10 days, failing petition stands rejected on its own. Yes. Item 15.
Please, your lordship, my lord, copy of the petition has been accepted by the opposite party number 1, my lord. And the notice has been sent to the opposite party number 2, my lord, through registered post, my lord.
I am for the bank, I have received instructions. Lord, if your lordship will kindly turn to Annexure 2, that was given by the proprietor who had taken the loan. He had taken 2 loans, my lord, one term loan of 55 lakhs and one cash credit loan of 5 lakhs since 2016. That became NPA on 28/9/2018.
Total loan is how much?
Well, 2.5 lakhs. One property has been sold. Less.
Because my lord, he is not.
Who is the petitioner?
I am the petitioner.
He should not be allowed to let him say. His client may be saying him. Yes.
My lord, the kind glance of the under annex 2, my lord.
Yes,
my lord, the page 14, my lord.
OTS.
My lord, the OTS letter has been issued by the opposite party number 1, my lord. And as per the portion to the letter, my lord, I have deposited, my lord, 7 lakhs, my lord. That is under annexer, my lord.
You were required to deposit 9 lakh for.
My lord, I have deposited 7 lakhs, my lord. That is under annexer, my lord, 3 page 16, my lord.
This is 9 lakh.
Some odd, my lord, 9 lakhs 4,006.
006. Now, out of this, you have paid 7 lakh.
My lord, I have deposited 7 lakhs within the third period. My lord.
Yeah. Remaining
that is under annexer 3, my lord. I have deposited, my lord.
Remaining 2 lakh 4,006.
My lord, the opposite party number 1, my lord, not obstructed me to deposit further amount, my lord.
Obstructed him.
My lord, they are not accepted 2 lakhs rupees from me.
Remaining.
My lord, my lord.
DD now.
My lord.
You have brought the DD. What happened to the other things? What precipitated?
Yes, my lord,
I am
not addressed.
Let me on. I am the not loan miller nor guarantor miller. My father was my lord. My brother is the loan miller. He fraudulently colluded with the opposite party number 1 miller. While my father was bedridden miller, he was affected by the cancer miller. I am the daughter miller.
Your father expired.
My lord, that is the fraudulently granted.
Your brother is the loanee.
No, my brother is the loan miller.
That is what. Your brother is the loanee.
My brother is the loan miller.
Father is the loanee.
No, miller. My brother is the loanee.
Brother is the loanee.
My lord.
Father was guarantor.
My lord. But my father was not put his signature, my lord. They manage another person, my lord. While my father was bedridden due to affected by cancer, my lord. and he is unable to move anywhere, my lord. It is the, my lord, 1 decibel. The property is 1 decibel, my lord. And 400 square feet, my lord.
Yeah.
And our residence house is there, my lord.
How much money is that?
My lord, 2 lakhs is pending against me, 2 lakhs something, my lord. I am ready to deposit, my lord.
Let us.
Yes, my lord, may kindly see Annexure 2. That was addressed to Sonali Icebrand, proprietor Prasanna Kumar Sahu.
My
It was
brother.
not addressed to the guarantor.
My brother, my lord.
That kindly see the date, 31/1/2022. My lord, and kindly see the paragraph 6, my lord, clause 6. So within 6 months, if he doesn't pay, it will be automatically cancelled. That is one part. But the one part that has been hidden by the petitioner is this, my lord, when this failed, and in another compromise of 20 lakhs, that 7 lakhs which he is claiming now, that was paid, and that compromise also failed. So that 7 lakhs is not in respect of this. In respect of this OTS, not a single amount has been paid.
That was in respect of what?
That was in respect of another OTS letter. That is
letter, but under the same
letter,
law.
not under this scheme, my lord. That scheme because he did
No,
not.
another loan or the same loan?
Same loan.
That's what we are
Same loan. I'm sorry, I misheard.
If you are silent, you can hear the voice.
My lord, I'm sorry.
If you make lot of noise, then the intellectual level goes down. Is it not? Therefore, Sigmund Freud said, the voice of intelligence is humble and meek. It should be humble and meek. Then your intellectual level is at the optimum. Otherwise, it goes down. Therefore, the cowherds, shepherds, they shout. We are not that. Though we wear black coats and gown.
So my first submission is, my lord, this OTS letter addressed to the proprietor Prasanna Kumar Sahu, he did not pay a single amount. Thereafter, he went for another compromise, my lord, not OTS. That was dated 14/6/22 for 20 lakhs.
14/6/22
for 20 lakhs. After failure of this. And in that respect, he paid 7 lakhs. And thereafter, he did not pay any amount. So that also failed. Now the present dues are 41,29,728. Your lordship, once I can file a counter affidavit to the enclosing those letters.
My lord, the opposite part number.
It's a false story.
No, my lord.
The letters he has given up 2024-25, my lord, they have never been received by the bank. No postal receipts or endorsement of the bank is there.
My lord, the opposite part number 2 is not deposited that amount, my lord. I am the depositor.
We are a rate court. We are in 27.
My lord, I am ready to deposit the rest part.
You pay entire, not rest.
9 lakhs.
Amount they are saying now.
9 lakhs, my lord.
No, the 40 lakhs they are saying, the 41 lakhs.
My lord, may see the decision of the apex court. That,
for what?
That OTS period is not within that period. That amount cannot be.
Yes.
My lord, within the time period, I have deposited that amount.
We do not want that. We cannot examine all that. No? Let me tell you did not deposit 2 lakhs.
But they have not allowed, my lord. Thereafter, they are
saying.
My lord, I am present.
Which bank it is?
My lord, within 6 months, they have not issued any notice to me.
State Bank of India.
State Bank of India.
My lord.
It's not some XYZ lender. It's a statutory bank. It's constituted.
My lord, the opposite party number 1, my lord, not issued any notice to me, my lord, for further deposit, my lord.
They will ask now. They have issued now, and you pay that money.
My lord.
Whichever. Otherwise, you go before the DRT.
My lord, I have deposited. Let me submit. Let me submit. I have deposited 7 lakhs, my lord.
You have said it 10 times now. It does not become 70. It remains to be 7 only, even if you repeat your argument. By repetition of argument, the amount you have already paid,
my lord, 2 lakhs is
enhanced.
My lord, 2 lakhs is, my lord.
You have said that. That also I have said. Petitioner is invoking the jurisdiction of this court against the coercive action of the OP Bank. First of all, learned counsel for the petitioner repeatedly submits that there was an OTS offer at rupees 7,04,006.
9 lakhs.
9 lakhs, 9 lakhs.
6, out of which 7 lakh, the sum of rupees 7 lakh was paid in time. And therefore, now he is ready and willing to pay the remainder with interest that is accruing due thereon. First of all. Per contra, learned panel counsel appearing for the bank submits that the amount due is is about 41 lakh. 41 lakh.
41 lakh.
41 lakh 29,728.
41 lakh
29,728.
lakh plus. And if the petitioner pays the entire money with reasonable installment facility, there will be no difficulty to for the bank to be lenient and defer the coercive procedure. First of all, he also tells that the petitioner can avail alternate remedy at the hands of jurisdictional DRT or such other authority as designated as do avail under the provisions of SRPC Act 2002. First one. Lastly, he submitted that the petitioner, the loanee is the chronic defaulter, and that twice whatever was compromised did not materialize because of his default, and therefore the court should not come to the aid of loanee. First one. In the next round, having heard learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned panel counsel appearing for the bank and therefore declining the first one. Ordered accordingly, and the petition is peaceful from.
My lord,
liberty to the petitioner.
my lord, my humble submission, the opposite party, my lord.
That's very enough.
My lord, my humble submission, my lord, the opposite party number 1, my lord, admitted that 20 lakhs has been fixed, my lord, finalized, my lord.
Item 16.
My lord, that amount I'm ready to deposit, my lord.
Yes.
Item 16.
My lord,
this order shall not come in the way of petitioner negotiating a settlement with the bank in accordance with the law. Okay.
My lord, give me protection to file, my lord. My lord, tomorrow they will auction my property, my lord.
Property. They have to know. Yes.
May I please, your lordships? Your lordship, may kindly see the order dated 10/9/2025 and 14/11/2025. A coordinate bench have been pleased to note down the facts of the case, my lord, vividly. My lord, this.
No, you said to look into. We are looking into. You only told that we should look into these orders now. They are long orders.
My lord.
We are not that fast in reading, so you have to give some concession to us.
Sorry, my lord. Sorry.
Anti-extremist training.
Yes.
So physical fitness can be ascertained even during the course of the training also.
9 months is the statutory period training. Thereafter, this is the next training in addition to the 9 months. Probation is for 2 years.
Specialized training he did not complete. Where is that specialized training?
It is at Rule 14, my lord. I can hand it over rules. This is available in the Read also. Yes. That is at page 58. It will be better. No, 58.
Training and special training. Running page 71.
The pertinent page is 71.
That is method of recruitment and condition of service of constable.
Yeah.
Method of recruitment.
Exactly.
256.
Yes.
Rule 14, training.
Rule 14 at page 71.
Very specialized training.
Exactly.
You have taken up the contention. Training plus specialized training.
Yes.
Where is that?
Training
plus specialized training. You said he has to undergo training.
Yes.
And specialized training as may be decided by the DG,
Yes.
Director General and Inspector General.
That is
Where
very
that?
much available in 14 page.
Read.
A candidate on being selected and appointed as a constable shall have to undergo.
Go back to the same one.
Page 71.
Read.
A candidate on being
it could be any other specialized training also. Yes, start your argument.
My lord, your lordship may kindly see the counter affidavit filed by the opposite party.
Now, what's your case?
But my case is that, my lord, I have completed the training. I have completed the provision period.
You were appointed on which?
My lord, I'm giving it.
27.
My lord, I was 27, 2009. My lord, My lord, 27, 2009, I was appointed, my lord. 24, 2010, I completed 9 months of basic training. We started from 27, 2009 to 24, 2010. Thereafter, I completed 2 years of provision period, 27, 2011 on.
Where is the specialized meeting? Training.
While I was deputed for specialized training, I had to undergo my knee operation. Therefore, I was relieved from the service and it was prescribed that I should do the light duty. Thereafter, discharge order from service was passed against me. I challenged this before the learned Orissa Administrative Tribunal, my lord. There, the opposite parties categorically averred in their counter affidavit that I have been discharged, the petitioner has been discharged from service as per Police Manual Rule 668A, which says,
slowly. Rule
668A, my lord.
6688.
668A. A, capital A. My lord.
688.
That I put it in page 4 of my writ application, my lord. Lord, it says,
why you went to the tribunal?
Because at that point of time, my lord, direct writ petition was not maintainable in the High Court.
No, what was the grievance before the tribunal?
Because I was discharged from service, my lord. On 2012, I was discharged from service, my lord.
25/8/2012.
25/8/2012. So immediately I approached the Honorable Tribunal, challenging the order of discharge.
Go to item number 5 in your date chart.
My lord.
Let me supply the date chart.
Yes. My lord, during treatment of his right knee, the petitioner was advised to.
Where is that advisory?
My lord, that has been in the additional affidavit. The state has also, my lord, annexed.
It has admitted that.
They have admitted it.
Yes, admitted it, my lord. And they have also stated, my lord.
That shows.
In pursuance to the order, my lord says read it on 14/11/2025. We have filed the additional affidavit in pursuance to the order of your lordship.
25/11/2025.
Which paragraph?
That is the medical board advised, my lord.
Yes, of their counter. Page 94.
My lord, page 3 of the additional affidavit, paragraph 5, my lord. Read. The opposite party number 3 under letter number 829 dated 7/6/2013 issued to the Chief District Medical Officer, District Hospital, Sambalpur, seeking medical opinion for reappointment of the petitioner. The petitioner appeared before the Medical Board, Sambalpur on 2/8/2013. The Medical Board recommended his joining in duty with advice to undertake light activity. Further advised to appear before the Medical Board after 6 months for verifying and recommending for SOG.
Yes, you're right.
But when I had challenged it, even the opposite parties did not bring it to the kind notice of the Honorable Tribunal. And now they are stating that under order 14 Miller, I have been discharged from service. But in the counter affidavit before the tribunal, they have stated that the petitioner was discharged from service by resorting to 668A of the police manual, which says removal or reversion during the period of probation. When I had already completed the probation period as well as the compulsory training period.
You completed the probationary period?
Period not on
2011.
27/2011 I completed.
There is declaration of completion of probation.
Yes, my lord, that has been admitted by the opposite party also.
We want to see.
My lord. It is in
CORAM.
My lord. Paragraph 3, my lord, of the additional affidavit. It is respectfully submitted that in due procedure of selection, the petitioner was selected as constable under 4th Indian Reserve Battalion, Devgarh, and joined on 27/2009 in pursuant to letter number 938 dated 13/7/2009 issued by the opposition party number 3. The petitioner had undergone basic course of training from 16/11/2009 to 15/9/2010. On dated 28/2012, the petitioner was deputed to undergo anti-extremist training, SOG Training and Resource Center, Chandaka, Bhubaneswar.
Where is the probationary?
Probation period. Provision minutes just now.
That basic training course includes your probation period.
My lord, my lord, includes the probation period, my lord.
But that was to be completed in 2011.
Where is the declaration that you have successfully, satisfactorily completed probation?
My lord, I'm just.
Mere expiry of the time period is not it does not take us to that conclusion. It's what Apex Court has been saying since several years.
My lord, he has, my lord, I'm sorry, my lord, I'm not able to show, but
have
it
you
is
been
there,
issued with that kind of certificate or anything is there?
Yes, my lord. That is admitted by the opposite parties also in the counter affidavit.
Mr. Monti, did you declare? No.
And 2 years probation, it has been well provided under the rule, Miller, under 13(3).
Correct. After 2 years,
yes,
was he continued in service?
No, my lord. During the tenure of completion of that drilling for 9 months,
there only has been discharge.
Exactly, because while they are in session,
where is your discharge?
This is at
discharge is at page 34, my lord. Page 34 is the discharge order.
Who drafts your orders? Come to page 34C.
Yes, ma'am. I'm 34.
Even a primary school English school student will laugh at this. So he discharged with effect from 25/8/2012.
2000.
On 25/8/2012, you should show that you were declared as having completed
Completion of-
satisfactorily your probation period.
Provision.
Declaration of probationary period is to be by a specific order.
My lord.
It cannot be inferred, though you are continued beyond that period. Supreme Court said in Maharashtra deliberated in one case, I am not able to recall that. That Samaraditya mentions that case. Take out the declaration of probationary period. The Supreme Court on declaration of probationary period. Yes. So, whole case, jugular vein of the case is that one only.
My lord.
If we show that you have been already declared as having successfully completed your probation, that particular rule which you said 668 capital A of the manual will not be applicable later. On that note, it needs to be set aside. That's the only case.
My lord.
Rest of the things are all nebulum. What the tribunal said, let us see.
My lord. Tribunal's order is that
how it is structured, what reasoning is contained in that.
It starts from page 73.
73, my lord.
73.
Yes, my lord. At place 74, Learned Tribunal has written that completed the probation period 19/7/2011.
Where is that?
What page 74, my lord. 1, 2, 3, 4, 5, 6, 7 lines, my lord.
Where you are reading?
Page 74, running page 74, my lord.
Factual backdrop.
The factual backdrop of the case is that the applicant being duly selected was appointed as constable in 4th IR Battalion Devgarh Annexure 1 on 27/2009. He has completed his basic course of training in the year 2010 and has completed the probation period.
Probation period is completed. Declaration of satisfactory
completion of the period.
Where is that? Completed probation period means his 2 years came to an end on so and so, and he is continued. That's how the Supreme Court has considered the matter.
My lord.
There should be declaration of satisfactory completion of probationary period.
My lord.
Saying that probationary period is completed does not mean that you have been satisfactorily declared as having completed. Which is that judgment? Huh?
Para 5 minutes of the impugned order. It starts from page 78. This has been clarified, my lord, by the tribunal. 78, penultimate para is paragraph 5.
All other things are only what was contended before it.
On hearing learned counsel both.
Years findings will be.
We noted that
My lord, that is Karnataka Road Transport Corporation and another versus S. Manjunath.
Correct.
There is no concept of deemed confirmation.
Deemed confirmation.
Deemed completion.
Completion. There is no deemed completion unless the rules say.
Unless the rule says.
Yes,
Yes, Manjunath.
No, brother, you have noticed.
You need to turn about.
Tribunal has considered. It has never said you have successfully completed the satisfactorily completed the provision. The contentions are urged. One side their contention. The level 7 line which you have shown. That is their contention. Your contention. Then the counter contention is from their side. That has been processed in page 70. It begins from 76. That was it. You see, come to 78.
My lord.
We have considered. Paragraph 5 on hearing learned counsel for both sides. From that onwards, findings.
My lord, my lord. My lord, your lordship may grant me one minute. I will, my lord, produce that completion certificate because
you take a review in the event you produce that certificate.
My lord, tribunal is not there, my lord. It is already been.
Therefore, we will not give you. We have spent all
you have also not taken that.
The tribunal has considered all aspects of conduct.
That is not case.
That is not your case also.
Yes, sir.
That was not your case. Where have you said that I have completed my probationary period successfully and so accepted by the other side?
You were treated leniently, and you have been asked to join in a lighter post, asked for the training, you didn't turn up.
And thereafter again he was given training,
yes,
leniency. See, we want fighters then. It is not some school job. We want fighters. Maybe with so many anti-nationals, anti-social elements for that. We want to choose the best and very, very fit person for fighting. Can we take, we want the soldiers like people there. Those who can ride the war horse, not the Tonga horse.
With great respect, in the additional affidavit, the state has stated that even similarly situated persons will later on given opportunity for training and reinstated into service. So what I respectfully beg, my lord, had the opportunity been given to the petitioner, he would have been completed, my lord.
No,
that has been stated by the state in the additional affidavit.
You have been given opportunity, you didn't turn up.
Even in the tribunal, they could have brought that letter. It was never brought to the light, my lord. Anywhere it is in the additional affidavit only, they have filed the letter. Not even in the counter affidavit before the Honorable Tribunal or before this Honorable Court.
What is the ground on which you are challenging? What is your articulate upon? That is rule 6888A.
A is not applicable because
the probation is declared.
Yes. Because I have completed basic course of training.
That makes no sense. Only during probation, the rule becomes invocable. You might have completed the training and still you continue to be on probation. Probation, Apex Court said, I don't remember. That is, but Justice Bachawat of the Supreme Court said, probation is an opportunity for the employer to observe the employee and for the employee to observe the employer. Then they will decide whether to continue or not to continue. It is not like honeymoon. It is not like honeymoon. Whatever bitter experience you will have in the honeymoon period will not invalidate your one. It does not allow one in the wedlock to leave the wedlock and go away. It's not the way. Probation. You do not become permanent employee till you are declared to have completed satisfactorily the period of probation. You being continued beyond the period of probation, Apex Court said, there is nothing like inferential successful completion of probationary period. No, Apex Court, these are the words which the Apex Court judgment uses. In one judgment, I do not immediately, I am not in a position to fish out from the memory pond, but there is such a judgment. And now Mr. Panda has said KSRTC versus Manjunath, a famous judgment. Nothing. Take off. A discharged police constable. Is he police constable? Constable.
Constable.
He is kindly be seated, knocking at the doors of the court for assailing the order dated go to the titles of
It's similar dated 19/12/2014.
19/12/2014, whereby petitioner's OA number 4272C of 2012 has been negative. First one. Next one. Learned counsel for the petitioner very vociferously submitted that the discharge of his client by the discharge letter dated. Sit down and answer. It's not a primary school. 25/8/2012 is bad in law in as much as the same has been issued under Rule 668 capital A of the police manual. What is that manual called as?
Orissa Police Manual.
Orissa Police Manual. In as much as his client had already successfully completed the probationary period. First time. The said rule having been structured with the building block of building block of probationary period, once that period is over, it becomes invocable. First time. In support of this, he drew attention of the court to several antecedents, such as training and second training, and the knee injury which his client suffered, and the advice of the medical board for allotting later work on account thereof. First time. Learned AGA, Mr. Mohanty per contra, resist the petition contending that making submission in justification of the impugned order of the tribunal and the reasons on which it has been constructed. First time. He took us to the text of Rule 668A of the manual and manual.
Policeman.
The probationary period having not been declared to have been successfully completed, the said rule is invocable. And in matters like this, a writ court exercising the limited supervisory jurisdiction under Article 227 of the Constitution of India cannot undertake a deeper examination. First time. So contending he seeks dismissal of the writ petition. Having heard learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the reasoning part of tribunal's order, which reads as under. Go to that page 78.
Para 5.
Put entire para 5. 78 it is up to 81. Next one. The vehement submission of learned counsel appearing for the petitioners that his client had already been declared to have completed successfully the probationary period post-training, and therefore Rule 668A of the manual is not invocable, is difficult to countenance. First off, the said rule has the following text. First off, below. The order of discharge reads as under. Next paragraph, one sentence you add. The text of discharge order dated 25/2012 12. See which date you have written?
And that was, I have seen it. It is a time, I have seen it.
So 100 years.
I have seen it.
The language, the intent and content of the discharge order dated 25/8/2012 accords with the text and context of Rule 668A of the manual. Next paragraph. The apex court in KSRTC versus Manjunath
2000 Supreme Court.
Yeah, 2000 Supreme Court.
SC.
INSC is available. 2000 INSC 238.
Bachawat Justice, Bachawat's judgment, famous judgment details. So, page number?
My lord, 2000 INSC.
2000
INSC.
INSC
238.
238 has observed as that. Got that on this one only. Okay? In the above circumstances, the petition being devoid of merits is liable to be dismissed, and accordingly it is personally been made. Next. Item 17.
In item 17, pursuant to Lordship's direction, the government has issued a letter to the office of the special officer of this Hon'Ble Court, that is as flag D. Your Lordship may kindly have a glance to flag D. That is letter dated 29 December 2025. To address the issue, the government has made certain query to the special officer. And the special officer in the meantime also replied back, but I was not having that copy. I just now saw and obtained the copies.
There are three questions.
Yes, sir.
Well, first question does not make sense.
That is not a question at all. That I have never said.
What is meant by the first question? Whether the post of copyist constitutes a regular appointment.
That word is inappropriate.
Post is a cadre post.
Yes, yes.
That he taught to him.
All throughout the pleading it was an ex-cadre post. All throughout the pleading.
Kindly see 14/11/25 order, my lord's order. That is the order must be complied by them. And there is interdepartmental communications. That is why the case is delayed. 14/11/25 order. Shall I read, man? My lord, make it precise. Entire case. Order number 30.
Time-bound advancement.
Yes. That revised assured career progression, RACP.
They want the period of
that period has now been omitted from our entire service period. That is, I shall read this order.
Remunerated. Remunerated
copist. Remunerated is I am not concerned. The copist period. We are remunerated copist. That is no use of our service. Yes. We have been made copist, which is a substantive post here. Brought over the Honorable Chief Justice directed them to absorb as junior assistant. We continue as junior assistant.
You were absorbed on which day?
Pardon?
Absorbed on which day?
2009-2003.
1 second. First you were engaged on which day?
This is 2000-2001. These different dates, all these persons were appointed and on a remunerated basis.
2000-2001.
My lord. The 39-2003.
Page 1.
39-2003, my lord. They were copist.
You were brought on the regular cadre on
39-2003.
All.
1 day.
Where is that order? Just show us.
Annexer 2, man.
Annexer 2.
Page 17.
Yes, sir. Shall I read?
Dated what?
Dated That is 39. Then in next page, the date is there with the memo. 39/2003.
Yeah, right.
If I
The following Remo is to complete the paperwork or continue appointed or copies with the same of payroll.
3,050 with the usual pay allowance.
Probation for a period of 1 year, the same not extended for another year. The order being. So you came to be appointed on temporary basis?
Yes.
With pay scales, with admissible pay scales?
Pay scale. On 36/2008.
1 second.
Well,
These are all temporary appointments.
yes.
With pay scale.
That is with this pay scale. That is the usual practice they used to pass orders. Well, now,
whether your probationary was declared completed.
That aspect is not involved in this case. Therefore, I have not obtained any instruction.
I have not part of the cadre only after declaration of the probationary period. There are such judgments.
Yes, that is not involved. I have to, if my lord put that question instantly, I cannot give it answer. I can collect the information. But what happened? The fact, just I am taking ahead on 36/2008, Annexure 3. They were absorbed as junior assistant in the same scale by the order of the Hon'Ble Chief Justice.
As junior
assistant, junior clerk, junior assistant, nomenclature junior order. All these persons.
Same pay scale.
Same pay scale. They were again given a promotion.
Promoted on which day?
To the post 29/4/2011. All were promoted to the post of senior assistant.
It is Annexure 4.
Yes.
And higher pay scale.
That is a promotion is a higher scale.
Higher pay scale.
Yes. Now, my lord, in 2012, a benefit was granted to all these junior clerks and senior clerks. They are merged to one cadre that is called ASO, Assistant Section Officer of this establishment. And that was given effect from a retrospective date 39/2008. 39, that Annexure 5, may kindly see, page 21. These are the undisputed facts.
Junior assistants and senior
assistant in the establishment High Court introduced new cadre, Assistant Section Officer, redesignated cadre, and superintendent level, that the promotional post.
It's a redesignation of cadre.
So what exactly, what is the rule here? The ASO, that Assistant Section Officer post, was created initially in the Odisha Secretariat. In 1948, when this Hon'Ble Court was established, after repeated from that Patna High Court. So there they said, whatever the service condition in the equivalent post in the Odisha Secretariat, the same benefit will be granted to the benefit to this employees of this Odisha High Court. The ASOs were, this post of merger and creation was on 39/2008 so far. The Odisha Secretariat is concerned. These employees of the Odisha High Court, they filed a case that we must be given the same benefit. That is why only in 2002, after that case was brought and we have succeeded, on 29/3/2012, the government of Odisha issued that notification that yes, all these junior assistant or senior assistant, they merge together and they will get the benefit of ASO. Retrospective.
Junior assistants become level 2.
Level 2. No, that is a promotional post. That is superintendent level 2 and superintendent level. That is another promotion post.
The basic cadre.
Basic ASO. These are the promotional grades. Level 2, level 1, all these promotional posts. To the ASO. ASO is the best level.
No, you read with introduction of new cadre of assistant section officer have been redesignated. Those who were in assistant section officer post was there? No. Senior assistant. Only post was junior assistant and senior assistant.
They merged together. They are
become ASO. All right.
Yes.
Now here you read
one ASO.
One ASO. ASO is one cadre.
Juniors and seniors will become one.
Yes, one. They merged, man.
Because it was the system secretary.
They diluted at one post. That is ASO.
Newly introduced cadre of ASO.
Mine.
The pay scale was also.
No, this is different. Now the pay scale become different.
Study commission and all.
Now, all these things, the pay scale was different. And virtually that became a group B post. Later on, it became a group. All these things, initially junior assistant, senior assistant, all the group C post. But after this introduction of all these things, new pay vision group, they became group C, group B. In the that grade pay was 4,600. That is the enhanced rate. Now they are ASO. Now direct recruitment to this Hon'Ble court is ASO. So for the clerical grade is concerned. Initially it was clerk, junior clerk, junior assistant, senior assistant. Now he wants to, has to be enter into the service or as ASO. That chapter is over. So now what happened? By virtue of this, on our resolution 29/3/2012, we are also taken to the cadre of ASO from 39/2008. There is no dispute. 39.
Is it promotion or not?
No. It is an absorption. That is a merger of the cadre, restructuring of the cadre, redesignation. It is nothing, no.
Neither
promotion nor nothing.
Earlier they used to be taught as junior and senior assistant.
Now,
because it was at par with the secretarial service, they were designated.
My lord has experience because yes, my lord was there.
Also remains same.
Same, my lord. Because with the change of pay revision and all these things, that changes. But there is no change in the status or like that. Man. So my case is also not that. Man. There is also no dispute. What happened in this case? So as I have stated, my lord, we come to the post of junior copyist on 39/2003, subsequently to the post of junior assistant on 36/2008. So that period of service, yes, was not counted for us for the purpose of this RACP. That period is just wiped out from us. But so for those junior assistant, initially those were appointed as junior assistant in this establishment, though they have given promotion to the senior assistant, but subsequently they became ASO along with us also. Their service from the junior assistant period was counted for the purpose of career advancement. That is that RACP. That is why
RACP is granted under which instrument?
That is Annexure 6 is the government guideline. Initially that is kindly see. There is the things. Page 43.
Which provision?
The first line, but that is also under an amendment. That is why now virtually there is nothing remain to be decided. This should come forward of that. That is why my lord I passed 1411 order. I will come to that. I will read out first this government finance department notification, resolution 6/2013.
Which paragraph?
My lord, may kindly see the time reading the first one, then the first paragraph 1 will go. The revised assured career progression for the state government employee. The state government considered the recommendations of the fitment committee and granted assured career progression (SCP) to the state government employee.
First ACP after 15 years.
Yes.
25. Second after 25, third after 30.
35.
Those who have not been given for career promotion.
My lord. So now,
it is in the nature of
financial obligation.
It is in the nature of compensatory, a little solatium-like thing.
Like that, because
those who have not got the promotion, they should not feel stagnated.
Yes.
And therefore, this some attraction is made there.
Yes, they must feel excited to work.
But later it has not been done. Even after promotion, they have received.
Yes, that was modified. That is also modified. Even if I got a promotion.
Time scale promotion is also there.
Also RACP also given. Because they say, if you have not get the increments, my lord got this. Because my lord's experience counts now. Helps me. So now, what happened, my lord, is one word is there important. That I have to see. That first paragraph, then paragraph 1.
Paragraph we have one read. Kindly go to next paragraph.
Next is revise that paragraph 1 itself. Next page, my lord. This is the clause. Revise assured career progression RACP scheme. What is this scheme? There shall be 3 financial upgradation under the RACPs counted from the direct entry grade on completion of 10, 20 and 30 years of service in a single cadre. Kindly take note of this.
Naturally.
No, that is now
if promotion is given. Where is the question of granting that advance?
Yes. No, my case will be now this single cadre, because they are now taking exception to this. This also been omitted. By subsequently. Yes. That is why what they say, when this single cadre was there, that is create the difficulty for them. Since we are in the copyist Now brought over to junior assistant, they say copyist and junior assistant, so they are continuing in one scale. But these are two different cadre. So since you have not completed this 10-year service in one cadre, you are not going to get it. That is they say. So now that they have been government after this, the difficulty is in
Where is that?
kindly see the last page of the.
Can we come after eating our lunch?
Yes, no problem.
And my learned senior brother is for the appellant. Not feeling well during lunchtime. I had a head drilling problem. So I just.
When do you?
On 10th, my lord, he's agreed.
We'll have it on 10th.
My lord.
Otherwise, he will not see time. Yes.
My lord, when you directed me to submit the date check, we'll give on the next day. Giving it copy.
You share it with them.
I have given it.
Next day.
And he that will I will go next day.
No, next day.
Best.
Next week is the request. Okay. Item 7 then.
Well, I wanted to know that modified resolution. That is at page running page 117. At annexure 17 mechanism.
17.
17, yes. That is of 13/2/2025. That in the cadre word has been deleted from that original. Kindly see the resolution. My lord, para 4. Therefore, in exercise power conferred under Rule 19 of the ORSP Rule 2008, the government is now pleased to bring the following modification in para 1 of para 10 of the RSCP scheme guideline issued by letter dated so 6/2/13. The word in a single cadre mentioned in the first sentence of para 1 of annexure 1 of penalty. That good, they deleted. So therefore now.
So even if in a single cadre,
that has
not
been
in a
omitted.
single post.
No, it is deleted now. Cadre is deleted. Because their original objection to us was that since you are a copyist, subsequently you will observe as a
Cadre comprises of whom all? Which all posts are there in the cadre?
Cadre, my lord, cadre defined in Rule 11 of the Odisha Service Code. It says the cluster of
posts. Bunch of posts.
Bunch of posts.
What are the posts now in this in the case at your hand?
Case in hand, my lord. Initially we were in the copyist.
No, that's we are asking.
Now in the ASU.
Cadre comprises of who all, which all posts?
ASU. Now we are in ASU, assistant section option. So now keeping in view this notification, kindly now see the order, my lord's order, the coordinate bench of this, while hearing this case, 14/11/25. My lord summarized the fact and directed my lord friends in the state to take instruction in this issue. May I read, my lord? I am permitted to read. 14/11/25 order. This writ petition has been filed by 6 petitioners for passing the letter dated 27/2/17. So also the letter dated 10/3/17 under 9 and annexure 9 and 10 respectively. And for a direction to the opposite parties to count the copyist period of service of the petitioners from 39/2003 to 29/6/2008 towards qualifying service for the purpose of grant of RSCP with effect from 39/2013. Inter alia, for a further direction to the opposite parties to calculate the differential arrear of the petitioners and to pay the same to them within a stipulated period. In the writ petition, government had taken that as per rule of the state government, an employee after completing 15 years of service in one grade is entitled to time-bound advancement scale of pay. And the same provision is made in a different nomenclature for assured career progression, SCP, under Odisha revised scale of pay ORSP Rule 2008. An employee became eligible for SCP on completion of 15 15, 25 and 30 years of service in one cadre grade. However, it was modified by the state government in the resolution dated 6/2/2013 by granting revised assured career progression (RACP) on completion of 10, 20 and 30 years of service in one grade cadre public grade. The order of the government dated 6/2/2013 has been annexed as Annexure 6 to the writ petition. Mr. Das and counsel for the petitioners.
Name of the lawyer should not be read.
Sorry, just I'm in the flow. I am ready. No. I'm just in the flow. I have read it. I never means. The line counsel for the petitioner has brought on record by way of further affidavit, which is dated 4/9/2025, in which he has annexed the resolution of the government of Odisha Finance Department dated 13/2/25. What I have read, man. Wherein the word in a single cadre mentioned in the first sentence of paragraph 1 of the Finance Department resolution number so and so 6/2/13 was deleted. Land counsel for the petitioner further argued that in view of such deletion, since the petitioners were in the copyist and as per the Odisha High Court.
Is it that deletion is with effect from which date?
It goes back to the date, well,
How do you say that?
because there's
Show that.
the Finance Department resolution. Shall I read it one second? Just let me complete. I will go. I will
No, we have read that already.
So
It is to show it is with retrospective effect.
it is never said it is prospective.
No,
Rather, it says
therefore it
like
is
this. Yes,
prospective.
therefore I am kindly.
Therefore, it is prospective.
My lord. What the has said that I am reading out from the beginning. 13/2/2025.
13/2/2025.
My
Your claim relates to which period?
Pardon?
Your claim relates to which period?
That 2003 to 2005.
Therefore, we have to ignore this.
Yes, kindly. Odisha revised scale of pay rule 2000.
Only relevant. Don't go on read.
Yes, the first paragraph only will read. That will be relevant, man. Madam, Odisha revised scale of pay rule, paragraph 1 of that notification, resolution. Odisha revised scale of pay rule 2008 was implemented by the state government with effect from 1/1/2006 by Finance Department notification dated 24/12/2008. Rule 15 of the said rule 2008 provides for assured career progression scheme for state government employees on completion of 15, 25, 30 years of service in absence of promotion. Thereafter, ACP was substituted by revised assured career progression scheme with effect from 1/1/13 by Finance Department resolution dated 6/2/2013, ensuring 3 financial upgradation to an employee counting from the direct entry grade on completion of 10, 20, 30 years of service in a single cadre in absence of promotion. However, revised assured career progression scheme is now embroiled in litigations. Hon'Ble High Court in Bihari Lal Bari case, that is WPC 2831 of 16, has directed implementation of the RSP scheme in a particular manner. Therefore, in exercise of power conferred under Rule 19 of the ORSP Rule 2008, the government is now pleased to bring the following modifications in para 1 of para 10 and para 10 of the RSP scheme guideline issued by Department resolution dated 6/2/2013. The word in a single cadre mentioned in the first sentence para 1 Annexure 1 Finance Department resolution so and so are hereby deleted. Para 10 of Annexure 1 of the said resolution substituted in the following paragraphs. So that is entirely substituted.
Where is what it says? The word substituted.
Yes. The para 10 of Annexure 1 of the said resolution is substituted by the following paragraph. Entire thing has been substituted by this. But it is there in the...
This resolution is made to give effect to a coordinate bench decision.
I can't follow that.
Yes. It is also
yes, Bihar Lal Bari. Sorry. Oh, sir. Yes, yes.
Where is that judgment?
That... probably it is not there now.
If you otherwise fall into the parameters of that judgment, then you can bank upon this resolution.
Just now it is not there. I will
only to give effect
I can
to
give
that
it
judgment.
by tomorrow. But today, just now, it is not. That is why that 1411, my lord have directed them to take instruction in the issue. What will happen?
This case is going on like this.
That they are not coming up with. Otherwise, it could have been finished from the day one.
You have also not got that judgment.
Yes, my lord, sorry. I will give it by tomorrow.
Not this matter. Yes.
Tomorrow.
10-3. 10-3. This is going on like this. Every time we spend half an hour and 1 hour and it goes like this. Yes.
Item 18.
My submission is that now the government has got the feedback from the special officer after making the query. Now, can the government reconsider, beloved? Their case.
Are you agreeable for that?
Yes.
Then no problem.
Then we will consider.
The whole of the things will be.
Yes.
Wait to again send this matter.
No, your lordship may see this letter has been addressed to the special secretary pursuant to that letter which I have read. That annexure.
Consider the entire issue.
Flag D. Flag D reply is this. Now the Law and Council appearing for the Honorable Court, my lord, may produce that. Because
On the last occasion, I have produced, my lord.
You already produced it.
But that is not flag mark. That is not on record.
Anyway, if it is the record, anyway.
Yes. Yeah, if your lordship direct that the government will reconsider overriding this annexure, impugned annexure, then it will suffice, my lord.
No, what you are saying now?
Lordship may see Annexure 9 and Annexure 10 at page Annexure 9 and Annexure 10.
No, if you are agreeable to reconsider.
Yes.
The claim of the petitioner.
Yes.
In the light of what?
In the light of the feedback given.
In the light of
the special officer's letter, which is
then say that and then let them take a decision in a time bound way.
Yes, time bound way.
May I submit only one thing? Lordship may kindly turn to page 77, running page 77.
77.
Yes, my lord. The case of the petitioner are that, my lord. They wanted to count their service with effect from 2003.
Correct. Because that day they came to be appointed
on a copy
basis.
On copy.
Full back the
Yes, my lord. The grievance of the petitioner is that by counting that period with effect from 2003, they should have allowed the RSCP benefits.
Right.
The RSCP benefits, as if your lordship kindly go through the page 24, which clearly stipulates that, page 24, my lord, in para 1. I am just reading one line of the para 1, my lord, page 24. There shall be 3 financial upgradation under RSCPS counted from the direct entry grade on completion of 10, 20 and 30 years of service in a single cadre in absence of a promotion. Yeah. But in the instant case, under Annexure 4, the petitioners have been given promotion with effect from 2011. So before completion of 10...
Promotion is given on 29 for 2011. So that will be how many years?
That is 2003 to 2009 years.
It will not be 10 years.
If 10 years. Since during 10 years, the claim of the petitioners that we have completed 10 years of service as on 2013 by counting 2003. So we should have allowed the benefit of RSCP. But prior to that, in 2011, since they have been given promotion for which they are not entitled.
Will not arise at all.
One answer to this directly. This Honorable Court, this High Court, kindly on to page 111. I have given the instances. All these junior assistants, page 111, man. They have granted promotion to the junior assistant, to the senior assistant. Also,
29,
2006. My lord, kindly see the names. Serial number 2, 8, 9, 10, and 11. These are the names. Next page, man. They are granted benefit of the RSCP by taking their first date of appointment irrespective of this promotion.
No,
Policy.
that makes no sense.
That is their man.
That you can't bank. You see, if you want
It is not a negative equality, man.
No.
It is not on negative equality.
You should permit us to say.
Yes, madam.
Apex Court said, a person who presses into service the principle of parity and equality for claiming certain benefit, service benefit, has to show what has been conferred upon others is in consonance with the policy. That if it is wrongly granted, we cannot direct them to repeat the same
This
wrong
is in
at all.
consonance with the policy. That is that Vihalal Vari case also.
Where is that?
No, that my lord have allowed me to.
No. Right. He has made it. That's the hitting the bull's eye. It is.
No.
This document
can you take note of?
We will take that one and then we first. Then that's the only point.
No, that Vihalal Vari takes care of a situation like
that
this.
Case otherwise we will not giving time.
I all it. That because today I don't have that. The my lord is giving.
You argued that matter last time also.
Which one?
You said that the coordinate bench judgment. No, mentioned that.
No, Vihalal coordinate bench judgment I have not argued.
You have mentioned that judgment.
No, probably not.
Last time. No.
Probably not, my lord. My lord may have mistaken. No, I have not argued. Vihalal Vari, there no reference.
That is already mentioned in the resolution.
Order resolution
Already.
is mentioned.
Resolution
I
is
have
already mentioned.
I have not argued.
So it forms
part also it is in the papers also.
Yes, record on the record.
What there on record? I don't have
this. I have not put it.
This is
escaped.
No, yes, that is why I am submitting, my lord. Kindly see, my lord. What I am to complete.
Or what we can do is, who has to grant the RSAP government? Government will you will restructure the judgment this way on your submission. In view of certain developments having taken place,
that
as is reflected in letter number 1143 dated 16/1/2026.
Yes.
Okay, we'll recall out it also.
Yes.
The matter is the petitions are disposed of, remitting the matter to the hands of the government for consideration afresh. Keeping in view the policy of 29/2000. Sorry, the policy which you have read.
Yes.
How you will be agreed with that order?
Then I have no objection to that effect. And that fact we have also narrated in page number 77. Page 77 we have narrated that.
Third length on more than one occasion. First time. A coordinate bench of this court, by the order dated 14/11/2025, had observed as under. First time. Thereafter, on 8 next time. We, in our order dated 15/1/2026, had made the following observation. In terms of this, a document is generated, wide number Roman 3. It is. So, which learned AGA has placed on record with leave of the court. First up, the same reads as under. Next paragraph. We will do that this way. We suggested to the parties that in the light of the said communication, the matter can be remanded to the portals of the government for examination afresh, keeping in view all the relevant orders, resolutions, and circulars.
And particularly, Your Lordship, may also specify this 13 to 2000.
13 to 2025.
Yes, madam. And Biharilal case is there already.
Which refers to another coordinate decision in which is that
Biharilal Barik case.
Biharilal
Barik, paragraph 3, resolution that paragraph 3, the Biharilal Barik case within bracket, that is WPC number.
Case
WPC number.
And in para 3 of the said resolution.
Resolution, my lord. Grateful.
Resolution. First up, they agree with this. You do not agree. Or you agree? For them to consider.
But taking into account the resolution of Finance Department dated 6/2/2013.
Learned panel counsel appearing for the registry of this court submits that even the resolution dated
6/2/2013.
6/2/2013, while annexure 6 to the writ petition,
which provides for grant of RACP benefit, also has to be looked into by the government. This goes without saying. First up. Next paragraph. In the above circumstances, one petitioner.
One petitioner.
Six. This petitioner.
More than one.
These petitions.
Petitioners.
Only one petition, there are 6 petitioners.
Are disposed of. This petition is disposed of. Accordingly, first up, the government will take the decision within an outer limit of 8 weeks.
3 months.
Why 3 months? All right, 3 months. Within an outer limit of 3 months. After giving an opportunity of hearing to all the stakeholders.
Grateful.
Yeah, otherwise, if you want to give this, that helps you. Stakeholder.
Notwithstanding that impugned order 9 and 10, notwithstanding 9 and 10, that should not be placed there while taking decision. 9 and 10 is the rejection order.
The order impugned in the petition thus pales into insignificance.
Yes.
Yielding place for taking a fresh decision.
In terms of Your Lordship's order. This order. Because Your Lordship had framed that.
All contentions are kept open. You may get one more set of cases after this. But they retake points, sir. If they have taken already promotion. Yes.
Item 18.
Of course. Much time wasting.
The 18 we have for the opposite party, but less than the counsel who was earlier appearing for the petitioner. Since he has expired in the meantime, I don't know if the matter has been, so it has been quite some time.
You are the only counsel on record. Then we will issue court notice.
But a court notice has to go to the petition.
Learned counsel representing the petitioner is said to have passed away. First up. Therefore, issue emergent court notice to the petitioner for making arrangement for representation if he so desires. He or so many.
That's
if it's so desires.
If it's so.
First up. Next.
Item 19.
We're challenging the learned tribunal's order, my lord. My lord, here the facts as follows, my lord. My lord, on 110.
What was the complaint before the tribunal?
Tribunal, actually, it was for appointment of compassionate appointment, my lord.
It was for compassionate appointment.
Yes, my lord. My lord, actually, there is a scheme which has been enumerated by the cell for compassionate appointment that finds place at page 43, which states that before declaring the person as medical invalidation, pursuant to that a certificate has to be issued, my lord, declaring a person that is medically invalidated.
Employee in her name.
Yes, my lord. If, my lord, that employee, in this case, in the instant case, what happened, before declaring the person, employee, as medically invalidated, the employee died. For which...
But he was in service.
He was in service. The scheme says so, my lord. The scheme is very clear that before declaring the person or a certificate to be issued as medically invalidation, if the person employee dies, then it has to be considered as natural death. So,
anyway, why natural? It is death also. There is death.
My lord, that is the scheme, that compassionate appointment cannot be extended, but there is a triggered also. Family benefit scheme will be extended to him, and in the
family benefit means what?
Family benefit scheme that I have, that is.
What is that scheme provide?
Yes, my lord. Page 7. For that, my lord, in that case, if they are the membership of the EFBS become the member, they will be paid the amount equal to the last basic pay plus DA of the deceased employee. That is 37,277 plus 2498. That amounts to 39,775 per month till the date on which the employee would have retired on attaining the age of superannuation 60 years.
Once. When
my lord, there is a trigger to that.
Okay.
Yes, my lord, because they have to deposit the final PF amount, PF and superannuation benefit fund, that has to be deposited first. Thereafter, this employee benefit scheme would be extended, and after superannuation date, that amount would be again reimbursed to the employee's family members. That is the scheme.
My lord,
and my lord, they have...
In order to save your lordship time, can I be allowed to submit one sentence? The compassionate appointment was rejected by the sale authority only on one ground. Clause 2.3 of their scheme.
2.3 of the scheme.
Which I was
doesn't allow to give me the compassionate appointment. That rejection order I challenge before the head. On the ground, it is absolutely unreasonable.
Let us see how the scheme, that particular clause reads.
And at page 43.
43. And the Learned Tribunal has given an order stating that the Patna bench of CAT has already quashed that very circular, that clause. In view of that, it
could not have been rejected.
Yes, kindly see the impugned order. Kindly see the impugned order. That is Annexure 15. And the last order passed by this Honorable Court under order number 21.
82. Impugned order finds place at page 82.
82.
My lord, kindly have a glance.
1 second, he's making submission. We'll hear you off.
My lord, because I'm only...
Yes, my lord.
Yes, to outside the time. Your lordship may kindly see. Tribunal in ON number so-and-so, in so-and-so case, which by the order dated 10/7/2017, the Patna bench of the tribunal, while negating the stand taken by the cell, directed for consideration the case of the said applicant for providing employment assistance on compassionate ground, quashing clause 2.3 of the circular dated 25/3/2011 as ultra-vires and unconstitutional. I do not find any such remarkable distinction to differ from the view already taken by the Patna bench of the tribunal. In view of that, the necessary direction was given. So under this very clause, the sale authority has rejected my application, my lord. And by the order number 21, the sale authority were directed, your lordship may kindly
reconsider.
No, the order dated 23/2024 by the order number 21. Your lord,
Of this court order.
Of this court. In the last hearing, this honorable court has directed that learned counsel for the petitioner seeks time to obtain instruction as to whether the order dated, that order which was referred by the tribunal. My lord, while negating the stand taken by SAIL, directed consideration of the case of the applicant for providing employment assistance on compensatory ground.
All right, they say ascertain whether that has been struck down or not.
That has not been done by
what should be ascertained? You have produced the order. The orders are there no?
Orders of the Cuttack bench. Now, Cuttack bench allowed the petition filed by the applicant, stating that the very clause
is struck down by Patna High Court.
Patna High Court. In view of that, the order, the Patna bench of CAT bench. So in view of that, the order of rejection
is bad
and cannot be sustained.
And therefore, what order is made?
Order was the SAIL authority was directed to consider my case to provide compassionate employment within 60 days.
Yeah.
That is
whether
84.
Whether SAIL has a unit there also.
We have.
You have.
The very
same. Here the pertinent question is that when the scheme is clear in its intent, can the learned tribunal can rewrite the scheme?
No, it has not rewritten. The paragraph based on which you had made the impugned order rejecting the claim for that benefit, that itself is struck down by the CAT.
My lord,
we have not completed.
Yes.
The problem
Sorry,
because we asked you to stop because he will cut it short.
Sorry.
The apex court in Kusum in God, as interpreted by various high courts in the country, where employer is saying the instrument of law, it can be an instrument of law under 13(3) of the Constitution, is by such employer, then the decision of one high court, here tribunal, because of SP Sampath Kumar, L. Chandra Babu, Chandra Kumar. If that is struck down, it is struck down for Orissa also. Number one. The only reason which you had given was what? In the impugned order.
My lord, the impugned order without discussing the merit.
You have quoted that one only.
My lord?
The order whereby you rejected his claim is that on the basis of that paragraph.
Yes, my lord. My lord.
Now that goes.
My lord, I am showing this Patna CAT bench order has been assailed before the Honorable High Court of Patna.
Yeah.
He has quashed that.
He is set aside now.
Yes, my lord. Issue and the issue whether the CAT has the jurisdiction to rewrite the scheme, that has also been discussed at para 27, page 13, page 28, para 28, para 30, 31.
1 second.
Yes.
You wait. Order dated 9/8/2007, passed by the CAT Patna bench, is hereby quashed.
I am not aware of that.
That's what you said. This is not upon which the principle of the provide the benefit of the safety in view of the benefit of sustainable extended. Para 56 revives that quashed paragraph because of quashment, which your friend was not aware of. Perhaps this is when it is decided.
My lord, on
24th January.
Yes, my
lord. Anyway, that is one aspect. Now we have to decide the matter as if there is such clause is in operation.
Yes, I want to go through that. Your lordship may call it after
2 weeks at the request of. Just look into.
Yes.
Whether any SLP is filed.
Yes, that I have
these things your person. In the meanwhile, look into that Kusum Ingot versus so and so. Although Mr. Fali Nariman, when he was there, he said that judgment runs counter to federal structure of the Constitution. Yes, just looking. Following that judgment, there is a division bench judgment of Karnataka High Court in 2010 or 12 under the Indian Divorce Act. Divorce Act 2019. Just look into and come back, okay? Then again, we will not give time. 2004 Supreme Court. Yeah.
Item 28, my lord. May I please your lordship?
Yes.
This is a case of disciplinary proceeding. Government employee, my lord, the death cert is given long back when hearing.
What was he?
She was appointed to the OAS Class 2 cadreman. My lord, kindly see the death cert. Death cert is clear. 1999. Appointed to OFS Class 2 cadre.
What is the date?
My lord,
Calendar has dates.
That was, I was. Now petitioner joined also to that effect.
Yes.
From joining till 31/3/2009, no adverse remark communicated to her while continuing in Treasury Wing, one of the 3 wings of the Finance Department of the State Government. Madam.
No adverse remark was communicated means. Can we infer that there were adverse remarks or there were no adverse remarks at all?
Not at all.
That way you should have stated. No adverse remarks communicated is an idea under the service law. There are adverse remarks, but they are not communicated.
No, not communicated in this sense, my lord. She was never communicated with any adverse remarks.
Yes.
For her honest, sincere, and devoted services.
Judgment by Justice E.S. Venkatramaya, father of Honorable Justice Agratna. Beautifully, this was considered. It's a classic adverse remarks communicated. Adverse remarks not communicated. What is the effect in service law? One judgment, beautiful judgment by Justice E.S. Venkatramaya of the Supreme Court, father of Honorable Justice Nagaratna. So beautifully painted. Mesmerizing language, the jurisprudential quality, quantum, simply sways away anyone. Anyway.
My lord.
Yes.
There are 3 wings.
We have not seen that. Go to next point.
My lord. My Treasury wing. From that Treasury wing, my lord, she was transferred to commercial tax wing of the state, joined as additional CTO in Jajpur range. That is 27/6/2007. My lord, got it?
In the same department.
Same department, 3 wings. Treasury one. My lord, my kindly see.
One can be posted as treasury officer.
Yes. Treasury part. Treasury part. Other is commercial tax for the government revenue.
Yes, said.
Yes. Now she is transferred to this commercial tax wing of Jajpur range. My lord, the powers of CCT were delegated under overt rules as published in Gazette 10/8/2007. It is to be published in the Gazette.
Delegated to whom?
Delegated. The power of delegation goes to the assessing official, my lord, the in charge of the ward. My lord, there is
against post of that particular area or what?
Yes, ward wise.
Ward wise. Means SCTO.
Ward wise, okay.
SCTO of certain ward.
My lord, range, my lord. There is a range. Range has circles. Then the circle have been divided into wards.
Understood.
Each ward has to be managed by
this assessing officer.
Assessing officer, the CTO.
additional CTO or CTO. So here what happens, the case is, my lord, the Jajpur Range Authority entrusted Ward C of Jajpur Circle, which had more than 15,000 registered dealers. Ward C given, allotted.
Yeah.
Other wards are manned by other persons, other officers. My lord, now let us come to 3/11/2008, last.
3/11/2008.
Last day. She has taken over as in 2007. August 2007, my lord.
10/8/2007.
Thereafter, 3/11/2008.
No, dates you are not given. Problem with this bar is they do not respect the calendar nor the clock. That's our problem. You go only on astronomical figures where days will pale into insignificance, even years may also. But we need everything to be date wiser.
Date is given, my lord. That's right.
What you have done? Go to the column number 4, 5.
Yes.
There you have not given the date.
No, not given because it is related to 10/8/2007.
Anyway.
That is why it is not given. But the mistake is that, I'm sorry, the internal columns of 5 and C, upper one line, my lord, 6 has to be merged. It was not merged by mistake of two.
Then,
my lord, 3/11/2008. She was entrusted with the additional charge of Ward B. Is entrusted with the Ward C. Now given the charge of Ward B of same circle, which had more than 15,000 registered dealers again.
why are you saying 15,000?
15,000. 1,500.
1,500. Yes.
Madam, I can kindly look at page 60, Annexure 1.
Page
60. Annexure 1. Madam. In supersession of previous orders, Sri Pratap Chandra Devraj Behera, commercial tax officer who has been assigned the work of Ward B of Jajpur Circle, Jajpur Road, by this order number so and so dated 18/7/2008, is hereby deputed to work as such commercial tax officer Kenjhar Circle, Kenjhar. This arrangement is being made in pursuance of head officer letter number so and so dated 39/2008 and 3/11/2008 positively for relieving Sri
He is asked to give the charge to your client.
My lord?
He is asked to give charge to your client.
Yes. They have decided unanimously without taking consent of mine. My lord, one word is consistently, sincerely to be taken by one office.
No, whether your consent is necessary for giving charge.
My lord, may not be necessary for the time being, but in usual course it has to be. I requested them to take over the charge of Ward B, but they did not. Now I came to the problem. No, that is why I am telling, my lord. That is why it is given.
Behra was directed to hand over the charge to your client.
My lord.
Then what?
My lord, in Jajpur range, range-wise, there is a central registration cell. I am deputed as the commercial tax officer. So commercial tax officer, what are the duties they is in overtake, my lord? It is all provisional, everything is given there. How to collect the tax.
Job chart is given.
Not job chart, provide statutory.
That's what? Statutory job chart.
My lord.
What all the duties he has to.
My lord.
Yes.
My lord, what happens? I am just forgetting the first column, second one I am coming up. Statutory duty of CTO and STO, it is annexed 2. Protection here given because they are doing quasi-judicial duties for assessing the state revenue. Yeah. They are given immunity. My lord, may kindly see page 2.
Page 2.
Annexed 2, sorry. Annexed 2, my lord. These are the, my lord, asking delegation. That is the delegation. That is the commissioner's delegation power to the CTO in one. My lord, may look at page 62. 62 page, it is clearly written.
Commissioner may by order delegate his power and functions.
That's a commissioner's power were deleted. Now, may I kindly look at the last, 62 last, indemnity.
Indemnity.
No suit, prosecution, or other legal proceedings shall lie against any officer or servant of government employed for the execution of the provisions of this act, overt act, or the rules for anything which is in good faith done or intended to be done.
Yeah.
Because it is a quasi-judicial work, so that is given order. I am protected. Now what else matter? Next, overt rule. Overt rule is gone. It is not necessary because range and circles have been defined. Now, the protection to officer under section 12 of the CST Act 1961. Well, that is in Annex 3, page 65. We have to deal with overt act, CST, and also anti-tax matter.
Now what happened?
Well, kindly can look at the primary.
That it duplicates that particular rule only, that law only. No proceeding, nothing, immunity.
Immunity. In the next, in CST Act,
it is not indemnity. Your legislature uses the wrong.
Given immunity.
Anyway, it is immunity.
Immunity.
Yes.
Now, the same thing is available in the CST Act.
Yes, we have.
Central sector. No suits, I am immune. And then next, under OET Act, Orissa Entry Tax Act, we have to deal with that. So there also,
immunity clause is there.
Page 66, Annex 4.
Yeah.
Yes,
Again, I am immune for all my discharge of duties for the state government.
Correct. You are right. Then,
my lord, I am quoting this High Court's order in one case.
The only thing is in the 33, without the sanction of the government, immunity is there.
Without sanction of the government.
Whether same word terminology is there in the other provisions?
No, this is OET Act. This is completely state act.
So there it is complete immunity.
Complete immunity to the officers.
Conditional immunity.
No conditional. It is all.
No, with the previous sanction of the government, you can take action.
Sanction, previous sanction, but it is not there, man. Others are, because they are immune.
Immunity is conditional because section 33, kindly read it.
That's the anti-tax act.
Allahabad High Court, British Shashikant had the same.
My lord, kindly look at Annex 60, page 68.
60.
68.
Yes, we are there. That's what we have read. Twice I have read, and therefore I am putting that question to you. With the sanction of the government, proceedings can be taken.
Taken out.
Next.
But no officer, servant of state government shall be liable to respect any such act or any civil or criminal proceedings if the act was done in good faith. That is important.
Yeah.
Now, I have annexed all the relevant provisions.
But you are not telling the facts.
I am not going to the facts because, my lord, it will be confusing. The charges made, that is, here we will find my. That's why I am telling. I will go on. Within short notice, I will go. My lord, may kindly see, a state cannot financially develop unless its trade and commerce flourish. This should be taken up in the mind of revenue authorities. Every citizen of the country has a fundamental right to carry on business. This decision was referred here as Annex 11. But I read it because what is the objective of the state? That is to be seen, my lord. Objective.
That is stated by Plato's Republic. So we'll go to further things now.
No, only point is to generate revenue. Now I have
sector.
Give as an octave.
Anyway, my lord. Thereafter, my lord, tax provisions are there, recovery of tax provisions are there, and the power of taking evidence by these officers are there. Now, next point is important, my lord. It is within circle, is meant to do all these duties. My lord, there is another factor. Since we are dealing with CST.
My lord, may I say one sentence, my lord?
Yes.
It's a certiorari proceeding, challenging the order of the honorable.
Sorry, please.
Tribunal, my lord.
Once, the other ones will go on like this one.
Tribunal.
Then go to cause of action straight, my lord.
Because in the order of the honorable tribunal is impugned, it is very necessary to see whether the OA, which was filed before the tribunal, is on record or not.
Yes, it is on record.
On OA has not been annexed.
Okay, I will show it.
And the grounds which is being now ours before your lordship, whether these grounds were ours before the tribunal.
Oh, we'll see that.
And the tribunal
We'll
will
see
not.
that. Please. Now, my lord.
Sir, you could not say that.
My lord, he is a younger brother, my lord.
That's all right. But still, the government.
My lord, government.
Entire state.
No, please sit down. I said, please sit down.
No.
Because don't.
You leave certain things to us.
My lord. I'm sorry. My lord. Now there are, after this, now only point I'm taking. Inspection provisions, last column. Inspection provision, checkpost and road, enforcement wings and business wings. To
Whether
check.
you are client or you are asking some question for
My lord.
for a clarification purpose.
My lord.
Whether any discipline proceeding was there against your client.
Yes, that is understood.
That's what we want to know.
My lord.
What were the charges?
My lord, I will go to charges straight away, my lord.
Come to page 204.
202.
204.
My lord, the memorandum 204 says, shall I place, my lord?
Yeah. Just you also read, we will also read. We are a bit slow compared to you.
No,
You
my
also
lord.
start. Go ahead.
I am sorry, my lord, if you like. My lord, two things given. One is pre-registration inquiry report. Another is way bill. Two things they have pointed out, my lord.
The tribunal, you challenged this before the tribunal.
Yes.
Ultimately, what happened to
My lord, the disciplinary authority became perverse.
Any disciplinary inquiry, you said reply to this.
My lord, because everything is written here, my lord.
No, we are asking.
Everything is written, my lord. Everything is written. Kindly look at page number 7, my lord, of the debt chart. I dealt everything. I am an open book now here. My lord, page 8, cause of action of debt chart. On the issues of pre-registration inquiry and grant of way bill, draft charges framed. Draft charges
framed. And inquiry was held.
Inquiry was not held, my lord.
Where is the order of punishment?
Punishment is at my lord, that is by order, that is answer 35. At page 314, please.
314.
314.
Censure two annual increments, 1 lakh rupees recovery, 20 equalizer installments.
My lord, recovery and withholding 2 increments without cumulative, with cumulative effect at those 2 major punishments.
Correct.
Censure is the minor punishment, my lord.
Correct.
But my point is whether the charges are maintainable, that is, it is to be dropped, my lord. That's why I'm telling I have to go to back. So what action I have taken as per the provisions and what they have charged.
All right. What were the contentions you had urged before the tribunal?
My lord.
Where are the grounds of which you had taken up before the tribunal?
My lord, tribunal's only order is at fine.
What we should do? How we will know what grounds you have taken? Everything should be produced.
My lord, I don't have.
Then that is the point. Therefore, you produce all those things. Otherwise, we cannot.
My point is, my lord,
Your point.
tribunal held only looked at the inquiry proceedings and said that the reasonable opportunity is given.
No.
My point is there was no reasonable opportunity. My lord, kindly look at my lord. I have.
So how will assess it, sir?
We have to assess the
my lord, I'm just putting you one point, my lord. This inquiry.
Basic document will not be. How can we assess?
My lord, my humble submission, what they have stated here,
What was
that
your-
will be all clear, my lord. My lord, my kind look at page 38, 39 of the writ petition.
So we want to know now,
My lord,
the grounds which you are urging before us in the writ petition,
my lord.
whether those grounds were taken up in the OA.
I was not there.
So we don't want, your client did not ask us before appointing you as your advocate.
No, my lord.
You were not, there is no answer. Whoever is there. Your client is there at least.
My lord.
Therefore, we want to know whether the grounds which you are now urging before us,
My lord.
were they urged before?
Or
You are making that statement.
My lord.
You enter the witness box, we will cross-examine you.
My lord.
That will not help you.
My lord,
You have to.
my lord, for a moment, my lord. Page 38, 1960.
Let him.
No, only very limited points, my lord. Only.
We will not look into because on the ground that you have not produced the OA papers, we are dismissing your petition now. On that ground itself, because there is judgment of the apex court. Whoever wants to challenge the orders of the statutory tribunal, they should produce all proceedings which were initiated before the tribunal. On that ground, we can dismiss this petition. That will not help you. Therefore,
My lord,
instead,
no defense, my lord, no defense statement. No cross-examination allowed.
Why defense?
No exhibition of documents. Contrary to charges.
We will request the other coordinate bench to look into this matter.
My lord,
you have determined.
My lord, I am sorry. Because for 7 years I have been harassed for this.
But you are not doing the needful.
I will do.
Go son.
I'll do.
Therefore,
I will
produce that. You produce the entire file.
Paper book.
Entire paper book before the OAT.
That you have filed with.
Then it becomes easy to consider your submissions.
Grateful.
Because very weighty submissions you have made now, which merit consideration. We agree. But for that, whether they were and you were not the counsel who appeared before the OAT. Therefore, there is more requirement. Learned, the petitioner is directed to produce the paper book in OA number. Look into that, huh? So within 2 weeks.
No, man. I'm sorry. I will be absent because I'm going.
You tell whichever date you want.
April 3rd week.
Huh?
April 3rd week.
April 3rd. Of course, call this matter in the 3rd week of April. It's a relief to us also, kind of. And the 3rd week of April, 2026.
I'll be absent for a moment.
No issue.
Item 21.
My lord, item 21, my lord, there is a noting that I have not filed the annexure 21 and 22, my lord. That has been filed, my lord.
You have filed already?
Already filed, it was filed.
Okay.
And so far as the copy to the other side, it is also filed today, my lord. My lord.
Ready in the matter.
Some other day,
My lord, I pray next week, my lord. 5th, my lord.
5th.
Because we have holidays are there.
When do you want?
1 week after.
10th, my lord.
Yes,
10th March.
Hold on. 12.
My lord, 10th, my lord.
10th we have posted billing values. It may not reach. Any difficulty on 12th?
My lord, from 12th to 24th, I will not be there.
So all this matter on 25th of March. All right, 25th of March. How many matters are posted on 25th? 2 matters. You post this also.
But
at the request of the net counsel appearing for the My lord, second copy of the brief I am also filing, my lord. You already uploaded, but it was showing that it has not been uploaded. The hard copy I am filing, one more hard copy.
You file it in the registry.
My lord, that will be recorded.
In order or not, they will look into.
My lord, that may be recorded so that the defects will not be
It
there.
is open to the petitioner to file the second copy in the brief file.
My lord, obligement.
Item 22. 22 minus. I am for the petitioner's mail. Then filing. It did not submit deaths are after taken some other day.
Some other day, yes. Call after 3 weeks.
My lord, my small prayer is that matter is of 2022. This is listed for 20 times, my lord. My prayer is a short date may please be put down.
On 17/3.
My lord.
How many matters are supposed to be done? Put that matter.
Item 23 has been adjourned. Item 24.
Yes.
Madam, the petitioner challenge the order of the London Tribunal by the
I'm telling my lord directed the officers to present in provide the form because they have got claim that we have signed. He is ready and he is ready to sign the document if he fill up the form and give it to the customer.
My lord, they may respectful submission before my lords. And the form 6 stipulates that the Honorable London Tribunal directed
this matter about
that the compulsory retirement dated 5/4/2016 has already been passed by the London Act. And my lord, the operation of the order, you kindly have a glance.
All right, it is passed, we agree.
Yes, yes.
What happened?
As a consequence, the respondent are hereby directed to grant the applicant all consequential service and financial benefit within a period of 60 days from the date of a received copy of this order. Then the Government of India approached this Honorable Court by challenging this order.
Yeah.
Thereafter, in Annexure
That is
2,
dismissed.
that is dismissed and confirmed.
Yeah.
Thereafter, I also asserted it and I approached to the.
Now, why are you filing? What is your case?
Case, my lord, that is the consequence of service benefits that has been misinterpreted by the Government of India. That is my designation was a senior clerk at the relevant time when a compulsory retirement order was passed. And thereafter, my retirement is due on my lord, on 28/2/2020. In such an intervening period of also 4 years that I am eligible to get promotion to the office superintendent and chief office superintendent. Even if my juniors has already been promoted, but they have not given such consequential benefits and they compelled us to sign in a form 6 and you take the benefit.
He wants to go on arguing.
My lord, sorry.
What the tribunal said?
Tribunal said that the consequential and a financial benefit
should be given to you.
Should be given. Consequential benefit not been given.
We understand.
Yes,
these are simple first year law student understands. According to you, consequential benefits means what?
That is that promotional benefit may be given. That OS and chief OS that as per the order, this Honorable Court also specifically directed by the order dated matter kind of a glance. That is the order dated 1/10/2024. Matter kind of a glance. Specifically, this Honorable Court said to the Government of India Council that London Council for the petitioner submitted that in the writ petition, it has been mentioned that the petitioner had not accepted the form as he came to know from the relevant source that the promotional post have not been given within the period of retirement, that is 8/2/2020. In paragraph 8 of the 82, wrongly 2082.
28.
That's a matter typography that is has been given. In paragraph number 8, the writ petition, it has been stated that petitioner appeared in person before the London Tribunal and apprised that it about the circumstances under which he was not able to receive Form 6. Thereafter, Mr. P.K. Padhi, London DSGI, appearing for the Union of India, seeks for an adjournment to obtain instruction in this matter.
This is the matter. Thereafter, my lord, they have not.
No, let us see. He is here, na Padi.
Yes, sir.
Yes, Mr.
It is a case where we are, according to the criminal order, repeatedly, again and again, we send the court. But it is clear, no, I am not ready to accept the, or as per the order of the tribunal, I'll accept according to my promotional avenue as well as other benefits, but there is here, which is separate cause of action, he can claim and whatever it is. But here is the specific order, let's make on the page 25. Sarla ticket to pro, move sir ke. What page 8, let's make come to the page 24. I'm just reading completely because Bismillah. I'm just coming to the 3 line after. A denial of the inquiry officer's report before the discovery authority takes its decision on the charges is a denial of the reasonable opportunity to the employee to provide his
Prove his innocence.
Yes. As a principle of natural justice. We also find substantial force to the stand for the applicant that order of punishment of the compulsory retirement at 5/4/2026 was not served on the applicant, which came to his knowledge when he was filed along with his counter filed on OA number such and such. That is 21/8/2020. Respondent did not produce any piece of documents that he had ever been served on the applicants as required under the rural law. Respondents have also not produced any evidence to substantiate that the date such and such is in. I'm completely relevant person. Next page, man. In view of again supported by the decision of the Hon'Ble Apex Court, such an expression in natural justice and legal justice do not present in the awaiting the classification. It is substantiate of the justice which is to be secured by both. And whenever the legal justice falls in active such and such, then let's say view of the above discussion made above, the order of punishment of the compulsory retirement dated 5/4/2016 is held to be not sustainable in the eye of law, in the eyes of law, and is accordingly quashed. In ordinary course, we would have, after quashing the matter of remitted the matter back to the respondents for a de novo inquiry, but taking into consideration the facts that the applicant has in the meanwhile reached the age of superannuation. For the ends of justice, we are for reference from doing so. As a consequence, the respondents are hereby directed to grant applicant all consular services and financial benefits for the within 60 days. Accordingly, we have submitted application form 6. They you fill up this set and submitted that personal direction. We are ready to pay. He has not accepted the form.
1 second. In form what all is stated.
Yes.
Where is that form? Which
in counter affidavit, we have page 47.
What is the order now put in challenge before us? You have put in challenge before us.
Before, sir, in this regard, when the government of India lost the case in
English first.
Repetition.
What is the challenge for this court?
This quarter that the contempt proceeding which has been dropped in Annexer 6, my lord, I filed the contempt petition CP number 19/2023 before the Lord and Cat dated, but they pronounced the order dated 28/8/2024 by dropping the CP, saying that you fill up the form 6 and the department is directed to settle the matter.
What is that?
Page 64 let me see.
66.
Page 64 ro arambo kari
my lord, paragraph page 567.
Where is that form which you want him to sign? Give that form.
Yes.
That we want to look.
Page 47 of our counter. The running page 114.
Mr. Padi, what is meant by service and financial benefits?
Yes. This is
well, let us sit down. It will help. Otherwise, we get unnecessarily.
No, I am sitting.
Anxiety.
No, I'm not interrupting, my lord. Sorry for that interruption.
What is meant by?
Well, at the service benefit was rendered to?
1 second.
Yes.
The punishment order has been quashed. Do you agree?
Yes.
Quashed. And the coordinate bench said, we are not limiting the matter for fresh inquiry because he had already attained the age of superannuation. Yes. Correct? Yes. Therefore, they directed grant of service and financial benefits. Yes. Correct? We agree with this?
Yes, we are giving so.
1 second. Yes. What is meant by service benefit?
Whatever period his service with till his superannuation, that period will count, and basing on that, whatever entitled to.
Service benefit means no promotion, etc.
No, promotion extra, but it is a case where superannuated, and yes, it was quashed. The university was refused because of this in getting superannuation.
Therefore, he retired.
He retired, and whatever period he is entitled to, we are giving.
Without promotion.
Without promotion.
How? What is meant by service benefit?
Service benefit.
Service benefit means if you have given promotion to juniors, that has to be given to him. Otherwise, endlessly, he has to spend his life only in the court corridors. That is not the object of creating tribunal.
According to me, there is a procedural system is this. Suppose anybody is entitled to some benefits were not given to, according to Form 6, he is to declare that this is my position, I have to entitled to such and such, but the department is refused to send, then he has some issue. He has not filled up the form, he is not submitting the same.
Let us see the form.
Yes. Let's say Lordship may see page 112, page 47.
Form now problem is
Form 6.
Now he wants to disturb you again. Why can't you sit down? Your standing is a nuisance to me.
No. Form. I am giving the form.
Brother, Mr. Padi.
Yes, sir.
Whatever promotions you have given to his juniors, that needs to be accorded to him. Because the order says service benefits.
Yes.
Plus financial benefits.
Because it is cost.
Yes. Because everything is bad.
Cost.
And court found everything bad in you. And they took a decision not to send this man to you because that would be sending the sheep to the wolf. That's how it structures.
That's
because you have seen no reasonable opportunity. Copies of the daily proceedings are not shared with him. The report of the inquiry officer is not given to him. That is in violation of Ramzan Khan. And by the time just you wanted to harass him for all these years, therefore court said, enough is enough. We are quashing these proceedings. And we will not send them for the novo inquiry because already he has retired from the post. So you want him to fight another legal battle for at another 10 years?
No, I am not saying so. What I am saying, whatever application is given to according to form page 47, running page 114 of our counter affidavit.
No, you say which post you will consider him for retirement.
Exactly, I can't choose.
You ask your officers now.
Yes.
Otherwise, we may take action against them. Otherwise, we will direct him first recovery from him, from his personal salary.
Well, this Lordship for a moment, Lordship.
You have harassed. This is what court has said. You have harassed the petitioner. Our petitioner is treated as if he was your slave. What is his designation?
His designation is.
What is your name? What is your designation? What is the length of service you have put in?
He is assistant personal officer of the East Coast Railway.
Yeah.
And according to him, what he says, the post was resignated.
At the time of retirement, he was but his juniors get promoted to the chief of superintendent.
You are saying that the juniors are getting the chief superintendent.
Yeah.
Basing on that, they will pay.
That is so big.
Yes, because he is not fill up the form and submitting the same, we are not to do it.
Where have you
He's copied the form. This is written. Let's see page 141.
Promotion post also is given?
Yes.
In the form itself?
The form is not giving declaration. This is the whole problem. Because you reaching this
because there is a blatant violation of principle of natural justice. Now he is scared of.
See.
He may be already without submitting the application. How can you say that we are not given anything?
No, that's not. See the judgment of Apex Court, which our Professor Sheshadri used to tell us very often. That is Rajasthan Electricity Board, Jaipur versus Mohanlal. Take up that judgment. Such a beautiful judgment. Where an employee was, after the electricity board was sent on deputation to another department. And by the time he came back, all his juniors were given promotion. And that promotion was not given to him. That judgment is such a beautiful judgment. The five-judge bench decision of Subbarao, Shelat, Mitter, and Bhargava. One of the classic judgments. It was prescribed as a textbook judgment for National Law School of India University in Bangalore, NLS. One of the classic judgments. The one paragraph you read, all these questions will not arise at all. Here is worse case because here not even a deputation, he is in the same department.
But here the case is little different. How?
No.
He has not submitted his form.
No.
He has refused the form. Unless he has not submitted the form.
You are
and
not
alleging that you are not giving to through.
Mr. Padi, yes. You are not that good in service law. Sorry to say this. Again, if you want me to prove that, I will prove it for all. That will be embarrassing to you. And to me also.
I'm sorry, my lord.
Here is an employee who was put to all kinds of harassment. Court did not permit to hold the inquiry also. The court did not permit to hold the inquiry also. Wholesale way, everything was set aside. And in the meanwhile, he retired on 28 February of that concerned month because he is not a constitutional functionary. He is an employee. Employee, regardless of age of remuneration, he will demit the office on the last day of calendar month in which he is born. Now, you are saying he should sign the form. You tell us in which post you are giving the terminal benefits and the pension ones. You tell us. We will make that order.
My lord, according to him, the officer is present. He is saying that his promotional post to those are juniors. What is their claim is that I am not giving the promotional post, all these things. I don't know what post is claiming, but according to their claim, according to us, the petitioners, those others are holding the post, promotional post. Their post is, what is the post? Chief Office Superintendent.
Very good.
Then on that post we are ready to, that's why we are giving the form.
Hey, brother.
He is not accepting this.
Don't speak. Ask your.
Yes.
Confused lawyers. Therefore, many
Redundant, I have stated so. Office superintendent and chief office superintendent, they are not given at all.
Listen to us. Many legislations are keeping the lawyers away. They don't permit participation of the lawyers because of this. Come here. Do you understand English? 2023. No, it's all right. We have read everything now. Do you understand English? आपको English आता है? Yes, sir. Come this side. Come this.
You come this side.
Read that form. वो form एक बार पढ़ो. Give that form. Do you have extra form with you? The form is here. You have produced also.
We have also.
Where have you stated which post you are giving in this? You have not stated. You are asking him to fill up the form. For which posts?
We have sent the application
all blank.
to them.
All blank.
Documents for the process of settlement.
No, all blank it is.
Yes, all blank.
You should tell in which post he will retire.
Senior superintendent.
Number one. Which post?
Chief Office Superintendent. Chief Office Superintendent.
Why can't you write a small memo and get the whatever you are saying orally? You give it in writing now. We'll make this order once for all. It will be over. Promotion you have to give as on the date you gave that promotion to his immediate junior. All right? That's the law. Because of Mohan law.
Then may I pray?
Yes.
Let the official file affidavit to the court. If hearsay or memo is, let them file affidavit.
Call tomorrow.
That's why come to.
Yes, Obran.
It should be official and record.
That's
I should not be mistaken by the court that.
But don't mistake us when we say certain things. It is not to hurt you. It is to place the fact on record. Therefore, whenever a judge says that it is not like this, you should fairly consider it. You need not say,
my lord, I never stand on the way of the court's view or the departmental view. I definitely, my work is to ventilate everything fairly to the court. It is my job, my lord. I definitely will cooperate in this regard. But only thing is this here is the case. One mistake we have.
Ask him to give.
Yes,
we'll make an observation now.
Yes, let's make observation. Yes.
Learned ESGI, Mr. Paddy, on instruction of the officer, she so and so, submits that the petitioner would be granted promotion to the post of Chief Office Superintendent with effect from the date his immediate junior was granted
promotion to that post.
Correct. And all his terminal benefits would be settled, including the financial benefits of such promotion. First of all, he seeks a short accommodation for filing the affidavit in this connection. First of all, call tomorrow. All right?
Item 25.
That should not harass any employee.
May I please, my lord?
Yes.
My lord, the applicant before my lord is a retired employee and matter relates to grant of third financial operation under MSF scheme, my lord. Though they have granted me, but my claim before my lord is that I am entitled third financial operation on completion of 10 years service in the second promotional post, my lord. So for the fact of this case, it concerns there is no dispute.
And the rejoinder.
Department, my lord, I have
department sought for a instruction to file a short affidavit within 10 days.
Call this matter after 2 weeks at the request of the DSTI.
Yes. My lord, the
Possibility of rejoinder.
67 years old, will also give it.
Will he become 68? Anyway, next.
Item 28. 28.
28, we have to petitioner, my lord.
Yes.
So, what did you, they have highly content condition. We need to do more. Then this department is coming some instructions. So can it be next week?
All right, we'll call this matter on 11th. On 11th. Don't precipitate the contempt matter.
Content is yet to be listed.
Yet to be listed.
Yet
But all right, but let him not have tomorrow we will post it any matter.
Yes. No. If the CP is coming tomorrow, let them not press. We'll next week, whatever is coming. Other follow with that. It's good.
Because it has not been yet notice has been issued.
Notice is not issued.
Resubmission.
Call this matter on the 11th week. Because in the meanwhile, the contempt proceedings, if any, shall not be precipitated. Yes.
Item 29.
Only pass over. Pass over. 20. That 330 we have near. 2018 matter. All right, pass over. Let us see if he comes in 5 minutes. Then we'll end good. Yes, 30. Agenda. Go to the weekly.
Item 32. 28 was passed.
28 passover is there.
If yesterday matter was there, my friend, my senior took them for tomorrow. Yes, 28.
28 is urgent.
Yesterday it was there called. My state government said that it will be taken tomorrow. On his request.
Which matter?
28, weekly list. Weekly.
Weekly 28.
Weekly 28.
Weekly 28.
Item 28.
weekly.
We are in 30. 30 has completed.
30 is supplement.
30 supplement over. Entire weekly list for entire week, 28 serial.
Correct, but which is the other matter, sir? Why to give jump the queue, which is call it in the serial number?
Item 32.
32.
Up to 30 over was completed last.
30 is completed.
28 was passed.
28 has taken.
Was passed over.
28 was passed over.
Yes, take 28.
28.
Index unknown.
What is this order, brother?
This is state appeal, my lord. Challenging the order judgment of the Honorable Single Judge passed on 10/11/2023.
There is a direction to reinstate it. This is pursuant to another set of order.
Here, my lord, there is a checkered history. First, it was an advertisement of 2003, my lord. 25/3/2003 for the post of Shiksha Sahayak. Shiksha Sevi Shiksha Sahayak, SSS. Then engagement order was issued.
Order issued on
26/9/2003.
Yes.
And joined on 11/12/2003. Joined on 11/12/2003.
Yes.
Engagement is 29 November.
29
November 2003.
appointment order.
Engagement order.
No, joined. Joined on
11/12/2003.
He is correct that engagement order is dated 26/9.
29 November.
29.
Just look into. Is it correct or not?
29/11.
29/11.
2003.
2000.
Joined on 11/12/2003.
11/12/2003.
That itself I was doubting that date because it would be 3 months almost. Yes. Yes.
While the matter stood thus, he was disengaged on 26/9/2003.
It cannot be.
No, sorry. 19/7/2006. Sir.
Yes.
One case was filed by namely Hrusikesh Bindhani. The other day, my lord has directed the whether that case would cover this or not. Hrusikesh Bindhani, whose case number is 1748 of 2003, which has been disposed of on 29/4/2004. Saying, there are some candidates throughout Odisha having the non-formal facilitators. They have the experience in service, and subsequently they should get the benefit to be appointed as Swechhasevi Shiksha Sahayak. But without doing so, by virtue of this advertisement, the freshers came into picture and they have been appointed. That was under challengement. Because they are not getting the preference as they are continuing as a non-formal facilitator.
Yes.
Therein, my lord, this honorable court was held
and quash the order and the operating part may
Order of appointment.
yes, ma'am.
Appointment or what?
Yes, ma'am.
What it was?
The letter by which this advertisement was made.
Okay. Advertisement
Yes,
itself.
sir.
That very
Copy may not.
advertisement is quashed. That was quashed when?
This was
29
passed
4
on.
2004.
Decision
29 4 2004.
2004.
29 4 2004.
Yes.
But the WP was filed in 2003 itself.
Yes. 17482.
It was filed in 2003, 11748. And even series of matters carried to Hon'Ble Apex Court, and that has been confirmed also. That's it.
What is meant by Swecha Sevi? Swecha Sevi Shikshak.
Swecha Sahayak.
Swecha Sevi
Scheme.
Scheme.
It is a scheme.
That is under the scheme.
Swecha
Volunteers.
Volunteers.
Oh, it is Swaicha. Not Swecha. And the Swecha is licentiousness in English.
Yes.
Swaicha is voluntary.
In the subsequent scheme, that Swecha is gone. Only Sikha Sahayak.
And the purpose is there should not be any dropout.
That's the objective.
That was the aim behind it.
Yeah, what objective was there? It was never successful.
Object was made Swacha. Read operative portion of the order dated 24/4/2004.
I am reading out. It is in the third page. During the course of hearing, of this case, considering the allegation of violation of the sports order, my lord, before that, this is from my lord, therefore, page 2 is the operating part.
Page 2.
The penultimate para, select list will be valid for 1 year. My lord, got it?
It's guideline.
Yes.
Relevant portion of the guideline is as follows.
Yes, ma'am. Select list will be valid for 1 year from the date of finalization. This will be 150% of the post advertised for the districts. Therefore, the instructions issued to the collector by the Secretary to Government School and Mass Education Department under Annexure 6 is contrary to paragraph 6.4 of the guidelines issued by the government accordingly. Annexure 5 is set aside.
What is that Annexure 5?
Can that file be called from Pusikas Midnight?
That WP.
Pusikas Midnight.
That has attended a final day after the Hon'Ble Apex Court's order. This order has been.
Whether this was not. This was not.
By virtue of this order, they have been disengaged. This present petitioner is one of them. Subsequently, they have preferred another writ application.
That is allowed.
That is allowed. And they have joined in service. And for the second time,
No, joint service what?
Second time they have been reinstated.
No, this 11748 was dismissed.
11748, that is Rusika Samindani, that is allowed.
It is allowed.
Partly allowed.
Partly allowed. That order I am reading.
Any saving clause is there? Any saving clause is there in the judgment?
No. Directed to make fresh advertisement for recruitment.
Did you make fresh recruitment?
Yes.
Made.
31/5/2006 to 2005.
You are in appeal now?
I am in now.
Against order of the learned single judge. Single judge directed reinstatement.
With all benefits.
Consequential benefit.
With an observation that the judgment is only applicable to the case of the petitioner.
Why?
Reason being, my lord, the advertisement was made on 25/3/2003.
Correct.
Of 9,500 posts for this post of Shiksha Sahayak. That a merit list was published on 3/7/2003.
Yes.
In merit list, my position is serial number 18, waiting 3. 2 months after, government passed a letter on 26/9/2003. You make appointment to another 15,000 persons without making any advertisement. That letter was challenged by Rusika Samindani before this honorable court. That letter of the government dated 26/9/2003 directing all collectors to fill up 15,000 some odd posts without making any advertisement was challenged before this honorable court. This honorable court observed.
Sorry. End up argument. Second rate argument. You don't stop. You don't allow us to process at all.
Sorry, ma'am.
Narrating endlessly. See, the order that was impugned before the in that WP 1748 of 2003, this was the order dated 25/3.
No, sir. No, my lord. 26/9. 26/9/2003.
26. No.
Para 3 kindly see, my lord. Para 3 of the judgment. May I permit it?
Yes.
Para 3 of the judgment. According to the petitioner, as per the resolution dated so and so, the government of Orissa in School and Mass Education Department select list prepared in respect of the post of Swachhasevi Shiksha Sahayak will be valid for a period of 1 year from the date of finalization, and this will be 150% the post advertised of the district. According to the petitioner, after advertisement was made as per Annexure 4, a list of eligible candidates was prepared. On 26/9/2003, Commissioner cum Secretary to Government of Orissa issued a circular wherein he directed all collectors of the district to recruit further 15,682 number of Swachhasevi Shiksha Sahayak in the state immediately. The Commissioner further advised that list of eligible candidates out of the pending applications should be kept ready so that instead of going for fresh advertisement of Swachhasevi Shiksha Sahayak, as per the need, recruitment be made from the same throughout the year. This was challenged and this was quashed, my lord. Honorable court said no. Can you see, my lord, the operating part? Next page, my lord. Therefore, the instruction issued to the collector by secretary to Government School Mass Department under Annexure 6 is contrary to paragraph 6.4 of the guideline issued by the government. Accordingly, Annexure 5 is set aside. The opposite parties are directed to make a fresh advertisement recruitment of 15,682 post of Swachhasevi Shiksha Sahayak. The petitioner reported to apply for it. So petitioner means Bindhani. Apply for the said post. So I am no way connected to 15,000 some odd post, my lord. So I was selected much prior to that.
6.4 of the guidelines. That is, this was contrary to guideline 6.4 of the guideline issued by the government. And Annexure 5 is set
Annexure
aside.
5 is set aside.
There were other cases also.
Yes, ma'am.
The impugned order is made keeping in view a particular leading case. Is it not?
This is the
This itself is
This case is the leading case,
This is the
which
case
we are following.
which was discussed in the impugned judgment of which is challenged by the study.
No, your impugned order. Go to your impugned order. Impugned order judgment.
This is judgment at 10/11/2023. This is available at page 58.
58.
No, there must be another order. This gives an impression that there is some other order which is followed in this case. Where is it? Learned counsel petition or present. Judgment prepared in separate sheets is delivered and pronounced in open court in the presence of learned counsel for the party, and order is passed accordingly as per. Where is the judgment part?
Page 58, my lord.
Page 58.
Huh?
Page 58. My lord.
58.
10/11/23.
This is 10/11. There are two separate rate applications. One is 19120. This is at 50. And 12813 of 2016. These two matters have been taken up
for consideration
together. And by virtue of this judgment, this was disposed.
They have said. Whether this judgment you have put in challenge?
This judgment is put in challenge, which is at 58 page.
Serial number? No, where you?
58 is single judge.
The single to challenge.
That is challenge.
That is at page 58.
You have put in challenge this order also.
Yes. 10/11/2023.
That is one.
Come to para 9 of that page 62.
Yes, ma'am.
Read.
Thereafter, since the petitioner was engaged on 29/11/2003 as SSA,
that is why Icha Shiksha Sahayak.
Swachhasevi Shiksha Sahayak,
Sorry.
and joined on 11/12/2003.
These dates match because those dates we only have.
That we have said.
We treated a regular teacher from 11/12/2009. Because 6 years he puts in.
After completion of 6. When other similarly situated persons recruited and continued pursuant to the advertising letter 25/3/2003 under Annexure 1.
They have been regularized.
Yes. As that of the petitioner from the select list were regularized, but the petitioner was denied the benefit and discriminated.
Yes.
He had approached the authority for regularization of his service as well as for regularization of his break period from 19/7/2006 to 11/2/2009. When no
2006 to 2009.
When no action taken, he had filed the WPC number 15038.
Your client, some other, that petitioner. Your client
My plan was terminate disengaged in 2006. After engagement to 2003,
I was disengaged on 19/7/2006.
2006.
On the ground that I was covered in the judgment of Husikas Bindhani. I approached this Hon'Ble Court, filed a writ petition.
That was set aside.
This Hon'Ble Court directed to collector. You examine the matter whether petitioner case is covered under Husikas Bindhani or not. On the direct collector examine, since that case was not covered, another engagement was issued in 2009.
That was 11 to 2009.
So I approached again to regularize that period.
That is 12.
12 to
2009.
Thereafter, I approached for regularization.
Of the order which was passed in 12278.
No, where that Rishikesh is discussed by the learned single judge.
This is my lord,
That the fresh engagement is 12 to 2009.
Press engagement. My lord, press engagement. This one. Because first engagement was in the bunch of the
2003.
All right.
In 2003.
He got disengaged in 1970.
2006. Then by virtue of the court's order, he has been re-engaged or fresh engaged 12 to 2009.
That you had challenged.
That I for regularization of that period, 2006 to 2009.
That 3-year period.
3-year period. That was not, no order was passed, no direction was given for consideration, they didn't pass. In 2018, again they disengaged me on the same ground that I am covered by Husikas Bindhani, which has earlier been disposed of by this Hon'Ble. That was challenged before this Hon'Ble Court, and that was squashed and directed.
That Rishikesh court held it is not applicable to you at all, because they only had said after the remand, the district collector himself said you are not covered under Rishikesh.
And also engagement order issue.
And re-engaged, you are whatever. From 12 to 2009.
They said not applicable.
Yes, Mr. Mohanty, very the case one.
Well, for that purpose, in order to make a compilation, I have also sought for the instruction from the DO Kendrapada, because after that also, so far the
district collector himself said he is not covered under
that has been taken care of in page 65 million.
And thereafter he was issued the appointment order.
The very appointment which was issued, later on it was recast. Prior to that, the total number of vacancy 146 was there, which was come down to 132. And this particular petitioner is belongs to untrained category and SC.
The 7 persons you had regularized also.
And that is the
after 6 years.
That is the abnormality after completion of 6 years.
Why not him?
But by this process, all must have been terminated.
No,
keeping in view
that
this.
is not your case. That is not your case.
My case is in twofold. One is Husikas Bindhani.
That will not help you because your officer said
another
after remand.
Another is out of 146, this has been reduced to 132. So far the particular block is concerned in Patamundi under the district of Kendrapada.
That was reduced in which year?
4/6/2003.
4/6/2003.
And you fit into that one only.
I was prior to that one.
Much prior to that.
Of the
engaged in the month of December.
November.
That is
November joined in December.
29/11/2003 engagement.
Yes.
11/12/2003 he reported for duty. Thereafter you sent him back saying that he is covered under Rishikesh. Then he challenged that order. Then matter was remitted to the collector to look into this. Collector said no, he is not covered under the Rishikesh order. Thereafter he was issued an engagement order. Then he filed. It was given on 12/12/2009.
12/2009.
12/2009. February. He said my previous service has to be counted. And that the learned single judges agreed. Then that you agreed. Then 2019 again you want to send him back saying that he is covered under Rishikesh.
2018.
Again.
Yes. How?
But apart from that, so far the percentage of vacancy and the recruitment is concerned, this was beyond that. Because there are only
15 persons are there.
How long-
Present petitioner is in serial number 18.
That contention is not now available to you.
Well, that has been
That
taken,
you should have taken.
that has been taken care of in the judgment itself.
Judgment itself it is taken care of. Otherwise also you are stopped from contending that because that you could have traded in the earliest of the writ petition. When you were
By
before
remanding back.
Because doctrine of constructive res judicata is applicable to the writ proceedings also.
The plea which you ought to have taken there.
Not taken, operates the res judicata. Dismissed agreeing with the reasoning of the learned single judge. Number one. The plea that case of the respondent employee was beyond the cutoff number does not avail to the state in as much as such a plea ought to have been taken in the earliest round of litigation launched by the respondent in WPC 11748 of 2003. Correct? 11748 of 2003.
No.
Not
One, two.
that is Rishikesh.
Rishikesh is 11748.
Which is your WP?
19-120-18.
19120 of 2000. No.
This is
You
the
will
one
want before
impure.
that.
Previous
Much
one.
before that. Nah.
One, two, 177.
12278.
Of 6 2000.
This is of 2006.
First half. In fact, the second contention as to the invocability of the decision in Rishikesh, so in WP 1748 of 2003, decided on 29/4/2004, also will not come to the aid of the appellants in as much as this aspect was examined by the district collector pursuant to the order dated
15-1-2007.
15/1/2007 entered in WPC
12278 of 2006.
2006. And while order dated
12-2009.
12/2/2009 held that petitioner was not at this order.
15/1/2007.
15/1/2007.
And re-engaged on
Held that he was
12/2/2009.
not covered under Rishikesh. And therefore issued the fresh appointment order dated
12-2009.
12/2/2009. Yes.
Continuation.
12/2/2009. First one. Thereafter, petitioner was disengaged in 2018, which is that order?
27-10-2018.
27/10/2018, invoking Rishikesh judgment itself. First one. This is nothing but a travesty of justice. That is set aside by the court.
That was set aside, that I should reinstate.
The same has been set aside by the learned single judge by the impugned order
10-11-23.
10/11/2023 with a direction to grant all benefits. First one. The things that have happened in this case would remind us only Alice in Wonderland, to say the least. First one. Dismissed. The appellants to give effect to the order of the learned single judge within a period of, it will impose cost, brother. How many times he should come to the court?
Because of this judgment.
No.
Will take
Where
care
was
of
this?
this.
Where was that? Your own district collector said he is not covered under the Rishikesh at all.
That
Then
was
he gave the
also
appointment.
under challenge mill.
Correct. That was remanded. Matter was remitted for consideration.
Well, that was also under challenge in 15038 of 2011.
Which one? There you lost. There you lost the case.
So for this cumbersome process,
You have to give at least 1 lakh rupees to him. How many times he should come to court? What is this harassment of the citizen?
because of that judgment, it was
Judgment, the district collector said he is not covered under that district that judgment, and he gave the appointment order.
that is true.
In
Subsequently,
2009. In 2009, he gave the appointment order.
12 to 2009 mean.
After
9 years.
But subsequently, when this order was challenged in 15038, considered the representation. That is the
How many times he should come to court? You give at least 50,000. You recover.
Kindly visualize our
This state will not.
because of the Rishikesh Bindani and the consequential advertisement.
Rishikesh Bindani will wake up from his grave.
But that is the crux of the point. Because of that order, all these process has been started.
Alright, if you do not implement, then you can.
That's what we take.
If the order is not full stop, make it a separate. This case cannot go without levy of cost. Because the petitioner citizen was harassed again and again, and he was made to approach this court again and again. Personal. Court corridors are not a happy place for spending life. First of all. Therefore, we quantify the cost payable at rupees 50,000 to the respondent employee. However, on the insistence of learned AGA Mr. Mohanty, the cost becomes payable only if the impugned order is not implemented within the time stipulated above. All right.
There are 8 weeks more.
No. 8 weeks, 8 weeks. This is harassment of the patient. First of matter, which is that matter?
Well, that
Yes,
item
Mr.
29. Item 29 of the supplementary list. Let it come tomorrow. It will take some time.
It's a little longer matter.
Yes.
Can we have it on 12th of
March?
Yes, 12th of March. Yes, sir.
Yes.
Two matters. What's the daily list? Well,